that is approved by this board must be implemented, constructed, or otherwise utilized within 2 years of the date of the decision of this board, or such approval shall expire. The decisions of this board can only be appealed in the Polk County District Court. So if you believe that you've been harmed by an error made by this board, your only remedy is to seek relief through the district court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong, you may petition the city council to change those regulations for future consideration. Any material written or otherwise used today as part of any presentation will become a permanent part of the record and will not be returned. You may contact staff after the hearing if you need a copy of anything that was presented at the hearing today. And again, if there's anything you're presenting with documents, photos, pictures, plan drawings, you will have needed to email those to planning@dmgov.org. We would also ask that you keep your microphone on mute other than when addressing the board, so as to limit any distractions during the hearing while it is in progress. We also ask that you refrain from using the chat or question and answer function in Zoom as part of this Zoom meeting. That feature will not be responded to, and it could be considered as what's called an ex parte communication, or communication outside of the formal hearing process. So that's my introductory comments for the hearing. And I'm only on video here for a few moments, again, to welcome you with a smile. But I'll be turning it over to staff here. And the only video you'll see from here on out on any presentations is going to be actual documents, photos, etc. But before we begin reviewing the agenda, Glory, did we have a few other people that we need to get clued in here on clarification on their identification?
We do. I just have 2 phone numbers, and if I will allow you to speak, and if you could please tell me your name, 612-720-6648. Unmute. I can't do it, so if you'd press *6 or #6, I'm sorry.
Is it #6 or *6?
I believe it's *6.
Yeah, okay. So if you're on your phone, you press *9 to put your hand up, in essence, and then once recognized, press *6 on your phone keypad, and then just give us a hello, and then we need to clarify your name and address.
Again, that phone number is 612-720-6648. Okay, I'm going to move to the next phone number. It's 612.
I'm sorry, I got it to work. I apologize.
That's okay. Sometimes it's tricky. And what's your name, please?
Amber Johnson. I work for Verizon Wireless, and I am here on behalf of my team today.
Gotcha. Thank you, Amber. Okay. And then again, I'm sorry, one more phone number, 612-360-3288. And again, that's *6. There we are. I hear you now.
Hi, good afternoon. It's Tammy Hartman calling. I'm a network outreach manager with Verizon Wireless. Thank you. I'm going to mute myself again here.
That's Tammy Hartman, H-A-R-T?
Yeah.
Perfect. Thank you. Mel and Bert, yes. That gets us all up to speed. Everyone who's here is named.
Hey,
great. Yes, thank you very much. And if we do have anybody that jumps on, like later on, Glory, we'll just cover that as if people want to participate. If we need to take a pause and get them caught up and recognized, we'll do that. Okay, so to kick off our hearing this afternoon, our first item will be to look at what's called, again, our consent agenda. Item number 1 is a conditional use approval request at 323 East Walnut for consideration to open a tavern or bar at that location. Staff is recommending approval subject to a list of staff recommendations and requirements that applicant would need to comply with in order to receive and maintain their conditional use permit. So staff is recommending approval, and as this is on consent, the board would be looking to approve this item without discussion, unless there's somebody present today or a member of this board that would like to open this item and have a full hearing for item 1. So is there anybody in the audience that wishes to speak on item 1 with any concern? If so, if you're participating by Zoom, again, please hit the raise hand icon in your little toolbar to be recognized. Or if you're participating by phone, please hit *9, and then staff will know that you'd like to speak. So again, anybody with any concerns with approving the conditional use permit request on our consent agenda at 323 East Walnut? I'll do a going once, going twice. All right, Glory, we don't see anybody. Is that correct?
That's correct.
Okay, all right. Any members of the board? If there's any member of the board that wishes to say something, just unmute yourself. If not, would there be a motion to, in essence, approve the consent agenda or basically approve the conditional use permit under item number 1? Anybody from the board want to jump in and make a motion for approval?
Yeah, this is Nathan. I'll move.
All right, so we got a, oh, was that Justin for a second?
Yes.
All right, so we got a motion by Nathan, second by Justin. We will have Tyler take roll call for votes.
Nathan Blake,
Aye.
Lynn Carlson,
Aye.
Dave Gare,
Aye.
Justin Gross,
Aye.
Marlis Jones,
Aye.
Cindy Smith,
Aye.
and Mel Pans.
Aye.
That motion passes 7-0.
Okay, all right. So we'll have the decision and order prepared for item number 1, and the applicant, and we'll get a copy of that next week. We wish you well in your business venture. All right, that'll bring us now to our regular hearing where we will hear each item as an individual agenda item and take testimony. Item 2 is a conditional use approval request at the vicinity of 1606 Center Street. And we'll have staff kick us off today by first giving a brief summary of the applicant's request.
Chair, members of the board, Jason Van Essen with the city planning staff. Just give me a second here to get my presentation shared with you. Well, that didn't work, right? Are you seeing it now?
No.
Just the agenda.
Yes, it's there, Jason.
There we go.
Okay, that was the opening slide. So just to go back to the opening slide, yes, we are reviewing a conditional use application for the setting of a small wireless facility on a utility pole within an area that's designated a local historic district is the short way to describe what that section of Iowa code is referring to. This is a map identifying the subject site. It's on the south and west corner of Center Street and 16th Street intersection. Photograph looking west towards the site. Closest to the intersection is a pole that's intended to be removed as part of this overall project. And the replacement pole you can see behind that would take its place with regard to both supporting the lines that you see running along there, and then with also the addition of the wireless facility.
Mm-hmm.
I won't spend a lot of time going through all these sheets, but they did provide their full design submittal set showing the location of the existing pole, the location of the new pole. You can see in this drawing a general design of the equipment that be mounted to the top of the pole. Close up. at any point the board or applicant needs us to come back to any of these drawings, we certainly can do that during my presentation or down the road during the item. Map showing some of the kind of the utility system in the area was in the package as well. The board and the applicant received a copy of the staff report. This is the first sheet of it. Won't spend a lot of time reading or anything to you, but we'll point out the criteria. There's 9 items that we look at for an application of this nature. The one that the staff report is focused on is number 7, which is the proposed use shall have no significant detrimental impact on the use and enjoyment of the adjoining properties. In the staff rationale, we make the case or believe that the application does not satisfy that criteria number 7. I won't read this verbatim, but I'll just highlight that we note that the character of a historic district is impacted by all physical elements found within the district. This includes visual clutter of utilities within the right-of-way. As you saw in the photograph, this is in close proximity to views of the front of the property in that corner, the Wallace House, which is both contributing to the district, but also has its own significance as well. In our recommendation report, we did note that there are other poles in the area that perhaps could work as alternatives or in alleys nearby. We've had that discussion with the applicant. They've indicated that it won't address their needs, but as staff, we weren't, it wasn't terribly clear to us, other than it's less than ideal to not have it in this location. So wanted to hit that as well. This is a response map. I think I didn't use the updated map. We do have a response from the Wallace House, which is the adjoining property. I have that in my presentation here. That I'll share with you. The applicant has had ongoing correspondence or communication with the neighborhood association and neighbors. This is a summary of that. We can come back to this at any point, or Mel, if you want me to leave it up long enough for folks to read. It is 2 pages. I think it might be best to let the applicant kind of share what they've had as far as correspondence, but we can come back to this if you prefer.
Yeah, I think that would be fine for the moment. If any of the board members have questions, they can ask. And yeah, we'll see what the applicant says.
Okay. And then I have a correspondence from Jack Porter. Same thing with this. We can come back to this as the board desires, just expressing his opposition to the proposal. We also had correspondence from the adjoining property owner, as I noted in my presentation, expressing concern and opposition. This is a photograph that they submitted. In their correspondence, this happened far enough back that they were caught off guard that the pole had already been installed prior to the board action. And then we have a correspondence from the neighborhood association president offering opposition to the proposal. And then yesterday we received this letter from the applicant, and I think when they give their presentation, we can come back to this if they would like us to, or if the board has questions on it. I also have some slides that they'll be presenting that I think summarizes what's in this letter, but I'll let them clarify that. And then they also provided a detailed response to the different criteria for the conditional use. And then, so with us focusing on 7, I'll leave their response to 7 up for a second if you'd like to read that. Mm-hmm. With that, I'm happy to answer questions, and I'll be assisting the applicant with their PowerPoint or slides as well.
Okay, board members, do you have any questions for Jason? Feel free to jump in. All right, Jason, I just wanted to verify, did you make a statement that a utility pole was installed specifically to facilitate installation of this cell phone service without permission? Did I understand that correctly?
Well, I don't know that it's fair to say without permission. This involves a coordination with the utility company. And so the neighbor, it was installed after our notices had gone out. So it suggested that. I believe part of it's the communication with the contractor wasn't aware that we were still having discussions. I will add, and I'm sure the applicant will point out that the direction from the Traffic and Transportation Division of the city is that the pole that's at the intersection, if they're going to use that, that pole needs to be relocated to a safer location than where that one is.
Right. Okay. All right.
And I have a question then in addition to that. This is Lynn Carlson. The pole, is that owned by Mid-American Energy or by Verizon?
I believe that's a Mid-American Energy pole.
Okay. So that pole is going to stay there no matter what. Because for Mid-American,
I mean, there's going to be a pole there. There was a pole there prior to the application. There'll be a pole there moving forward, regardless of application. Yes.
Okay. Thank you.
Okay. All right. Any other questions for Jason? Okay. Hearing none. For the next part of the hearing, the appellant has up to 10 minutes to present their appeal. Now, for you folks at Verizon, I know there's a number of you present here today. So you have 10 minutes to present your reasoning for your case. And we hold people pretty strictly to that requirement. So if you plan to have more than one person present during that part, we'll want to make sure that we're aware of who that's going to be as you transition to the next person. But again, you've got up to 10 minutes to present your appeal. If you do have any questions about that process, please let me know. Who wants to kick it off for Verizon? All right, looks like we've got a raised hand here. Bert, you're helping us with that, right?
Yes, it looks like John Palmtag should be able to speak now.
Hello, everyone, members of the board. Can you hear me?
Yes, sir.
Okay. Is it possible for the board to unmute 2 or 3 of us so that we can jointly present in this presentation?
Yeah, it looks like Emily is unmuted. Who else did you need to have unmuted? Anna?
Sherman, Anna Kristolich and Sherman Botts, if he's raised his hand and if you can.
There we go.
Yeah.
Okay.
All right. Thank you. Good afternoon. I'm Sherman Botts. I appreciate the chair and the board giving us the opportunity to appear today. I'm with the law firm of Stinson LLP, located at 1201 Walnut in Kansas City, Missouri. And I'm appearing as attorney of record for Verizon this afternoon. I'm licensed to practice in the state of Iowa. And in fact, I grew up in Iowa and I'm proud to say I went to Drake University for both my bachelor's and master's degrees. I'm joined here today with Verizon representatives who will speak in our allotted time. With me is Emily Maluski and John Palmtago, and they'll present a slide presentation. I also have another Stinson attorney with me, Anna Kristolich, and she will speak to the CUP criteria. We also have with us Verizon RF engineer, Matt Bennett, who will be available to answer any technical questions you may have. So with that, I'll turn it over to Emily Maluski, please.
Hi, this is Emily Maluski. Are you able to hear me?
Yes.
Great, thank you. If you could switch to the next slide, please. So this first slide is brief background and timeline of our application for this small cell site. It was originally submitted in January with a batch application with 8 other small wireless facilities. Those 8 other sites were approved and have very similar equipment to what we're proposing for this Sherman Hill site. We pulled this site out as it was identified as a historic location. You can move to the next slide, please.
Hello, this is John Palmtag again. Throughout the presentation, of course, we're going to hit the criteria for the CUP process, but we did want to focus on 2 main issues that the staff identified previously in their report. The first issue was that attachment of our radio equipment to the existing Mid-American electric pole may provide an obstacle to future undergrounding. In short, and we can talk about this later as well, we don't think that's the case. As mentioned, this is Mid-American Energy's pole. In the future, if Mid-American Energy would choose to, or if they were required to remove the pole and underground their lines, that would be Verizon's problem. We would have to remove our radio equipment, and we would have to find an alternate location if there was one that's technically feasible while we work with the city and the neighborhood. The second point is that I think the city believes that there may be alleys that would be technically feasible for this deployment. For a number of reasons that we'll talk about through this presentation. It's just really not technically feasible given the nature of the technology, as well as the infrastructure already in that alley on the block. And if you could change to the next slide, please.
So as this is a more updated photo. We saw a previous photo shown by Jason, but you can see the existing pole on the corner and then our new pole. Well, it's Mid-American Energy's pole there to the west. And the city had originally requested that the existing pole on the corner be removed and relocated to the new spot because of safety concerns, because that pole is located in the turning radius. And so that existing pole will be removed, and there will still be just only 2 utility poles in that right of way, and no additional poles will be added. Can you move to the next slide, please?
So this is an example of a currently installed small cell that's of the same technology and type. It's on 1605 9th Street in Des Moines. If you notice, the radio equipment is the gray equipment at the very top. So it's top mounted. It's very small. It shouldn't cause any visual clutter. It doesn't really impose any restrictions on sight lines in the neighborhood. With regard to the technology, this is the fastest stuff we have. So it should provide tremendously increased download and upload speeds to the neighborhood. Unfortunately, due to the laws of physics with these radio frequencies, Matt Bennett's RF letter gets pretty deep into this, and I'll just kind of skim over the top. But due to the nature of physics and these frequencies, they don't travel well through buildings or through dense foliage. That poses a pretty significant issue for our site selection in neighborhoods like Sherman Hill. Sherman Hill has a lot of old growth, beautiful, dense foliage, and a lot of multi-story houses relatively close together. So it's very important in neighborhoods like that, in locations like that, with this technology, that we get as close to our target coverage as possible. We really are limited in those situations to line of sight coverage. So we try to go into the right of way as close as we can to the roadways or the intersections. In this case, our goal is to provide coverage, line of sight coverage to Center Street, east and west, and north and south along 16th Street. And the closer we can get to the intersection, the better it is for coverage. Next slide, please.
So in addition to the way the technology works and that it's better with line of sight, we actually did have our engineers go out and look at the alley and take these pictures to see if there are poles that would be possible for us to co-locate on. And all of the poles that are located in the alley currently, we cannot go on because Mid-American Energy does not allow us to co-locate on these poles because they contain transformers or U-guards, and it presents a safety risk for us to co-locate on these poles. So there currently aren't any pole options in the alleyway that will work for our technology.
And even if there were, you can see from the photographs, there's a lot of dense trees and foliage in the neighborhood, as well as relatively tall houses on both sides. Effectively, we would only be able to provide coverage to that alley and the block itself. We wouldn't be able to access or provide line of sight coverage to motorists on Center Street or 16th Street, which is really our target coverage model for this deployment.
And you know, our customers aren't hanging out in the alleys. People hang out on the sidewalks and in the streets and driving their cars, and that is who we want to reach and provide the best service to.
Next slide, please. So Anna Kristolich should provide the analysis regarding the criteria and how this application interacts with those criteria.
Correct. This is Anna Kristolich. Can everyone hear me okay?
Yes.
Yes.
Great. Okay, so I will try to run through these fairly quickly. I know we're running out of time. So for the first criteria, the location and operation of the small wireless facility will adequately safeguard the health, safety, and general welfare of persons near the site. As they previously discussed, the replacement mid-am pole was moved to the west to provide more turning clearance for the intersection, and that is in order to improve safety. The old mid-am pole will be removed. RF emissions of the small wireless facility are well below FCC safety limits. We believe that the small wireless facility will actually be a benefit to the community because it's going to increase wireless network capacity and reliability, especially now with the exponential increase in the demand for wireless service during the pandemic. Emergency service providers and residents who contact them rely on the network, and many people no longer have landlines and rely exclusively on cell phones. Next slide, please. The second criteria, the small wireless facility will not impair the adequate supply of light and air of surrounding property because it is located at the top of a pole. Next slide, please. So for criteria number 3, the small wireless facility will not increase congestion in the streets or public danger of fire, safety, or flooding. No portion of the equipment will be located on the ground. Next slide, please. The small wireless facility will not impair nearby property values. It is very low profile. It's located nearly 30 feet above the ground where most people won't notice it. And it will improve Verizon's network capacity and reliability, which is valued by prospective purchasers. Next slide, please. The proposed small wireless facility is consistent with the general purpose of the zoning ordinance and the comprehensive plan. It complies with FCC regulations, the Iowa Cell Siting Act, and all applicable zoning regulations. It's located in the Annex 2A zoning district, where the zoning regulations specifically allow the small wireless facility with CUP approval. Next slide, please. The proposed small wireless facility is consistent with the comprehensive goal of protecting the historic assets of the Sherman Hill Local Historic District. Verizon will not be adding a new pole that will increase any visual clutter in the right-of-way because the small wireless facility will be co-located on the replacement mid-am utility pole. The small wireless facility is very low profile. Again, it's nearly 30 feet above ground level. There will not be any ground cabinets. It will have a minimal impact on the character of Sherman Hill. Most people won't notice it. The small wireless facilities are the most modest deployment that telecom companies can provide and are deployed instead of 100 feet tall macro sites. Next slide, please. The small wireless facility does comply with the design requirements in section 134-4.7. It's minimally obtrusive. It reasonably matches the mid-am utility pole, which doesn't have decorative elements or lighting. Next slide, please. It's located at the top of the mid-am pole in the public right-of-way where it will be minimally visible. Next slide, please. The height complies with the limitations set forth. The pole is 29.5 feet. With the small wireless facility, total height is 32.1 feet. Next slide, please. As John mentioned, the site is not included in an existing underground district, and Verizon is not adding a new or additional pole. In the event, as he noted, that an underground district is adopted, Verizon will remove the small wireless facility. Next slide, please. Again, the site does not involve a new or additional structure because Verizon intentionally utilized existing assets in the public right-of-way in order to avoid adding a new pole.
Okay. I'm going to ask, I'll give you another 30 to 60 seconds here, but I want to get you guys to wrap up. You've exceeded your time by a pretty good margin here.
I have one more point. If we could go to slide 19.
Certainly.
The small wireless facility will have no significant detrimental impact on the use and enjoyment of surrounding properties. And it is because of the previous discussion about its low profile. It will be co-located on a replacement mid-am pole that is going to be there no matter what. No additional poles will be added to the public right-of-way. And as noted before on slide 12, there are descriptions as to why it will have a minimal impact on the character of Sherman Hill.
Okay.
So in sum, we do believe that the facts establish the criteria that are required by law for granting the CUP.
Mm-hmm. Okay. All right, group. Are you prepared to entertain some questions from the board members?
Yes, we are.
Okay. All right, fellow board members, any questions for the Verizon staff or their representatives?
Mr. Chair, this is Cindy Smith.
Go ahead.
I'm not sure if Verizon knows the answer to this, but as they were speaking, I was curious what other if other cellular companies have equipment in that vicinity. I'm thinking of US Cellular and maybe some other providers. I was just curious if they knew.
Ms. Smith, this is John Palmtag. I don't believe any of us are aware of any competing or competitors' installations in Sherman Hill.
Yeah. All right. Other questions?
Mr. Chair, this is Lynn Carlson. I have a question. So we went through some of the slides really quickly, but up the pole, how much area does this add on to the pole? Are we talking 2 feet, 3 feet? And how wide? The height and width?
This is John Palmtag again. I believe the existing pole is 29 and a half feet. And I believe the radio equipment adds another 2 to 3 feet on top. And as to the specific width, and I don't have those numbers, but it's certainly within the definition of a small wireless facility in Iowa code. And it's the best description we could give you is the photograph in the slide.
Okay. Other questions?
Mr. Chair, this is Cindy. I just have one more clarification. I thought I heard someone say that Mid-America does not allow co-location on any of their poles in the alley. Did I hear that correctly?
Hi, yes, that was Emily Maluski, and I did speak to that point.
All right, thanks.
And to clarify that, it's because those poles have transformers on them and U-guards. So they are already equipped with quite a bit of equipment, and they don't allow us for safety reasons to put our equipment on those types of transmission poles.
Thank you.
This is Marlis Jones. I have a question then.
Yes.
Part of the staff rationale, they say that there are utility poles in the nearby alleys that the appellant could potentially co-locate on. So that's in direct contradiction to what Verizon just said.
Mm-hmm. Mm-hmm.
Yes, that's correct. We did have engineers go out and look at the poles in the alley. And not only does it not allow our equipment to reach our customers fully, and it doesn't propagate as well, there also aren't any existing poles in the alley that we can co-locate on.
Mm-hmm.
Okay, so I wonder why our staff think that you can.
I'm thinking it's because they probably aren't privy to those conversations with Mid-American Energy. And, so we did look into it further to see if that was a possibility, and it's not.
Ma'am, this is John Palmtag again. Even if there was a pole that we could co-locate on in the alley, Unfortunately, with the radio wave characteristics, we wouldn't be able to provide effective service to almost anyone that we're targeting. It would effectively just be, with all the foliage and with the housing in the neighborhood, it would effectively just be the backyards on that block and the alley line of sight going north-south. So as Emily mentioned during the presentation, we're really trying to focus line of sight on Center Street as well as 16th Street. And for that case, we need to be in the right of way near the intersection.
Right.
And Mr. Chair, this is Cindy again. I'm assuming as a vendor, Verizon's heard from customers or their clients that the service isn't that great. You know, what can you do to enhance it? And I know there was a mention of folks working at home. Obviously, I'm remote now, COVID, so I rely heavily on my cell phone and also on my internet. So I'm just going to assume that there was requests from the folks in Sherman Hills who need possibly better coverage or better service.
Is that a statement or a question there?
Well, it's kind of just my assumption. And if Verizon has anything to throw back at me with that, then I'm willing to, I would love to hear that. As a customer, if you don't have good coverage, you often call your, whether it's USL, Verizon, whomever you call to complain. So I'm just throwing that out because I understand the importance of working remote.
Right.
So yes, those are good questions. I think everyone does want the best coverage possible, right? And Verizon Wireless is trying to provide the best possible coverage in Des Moines that's also the most reliable. In the case of this small cell equipment, this provides the next generation level of service. And certainly within 2 or 3 years, as new cell phones are purchased by our customers, this type of radio frequency service will be in very high demand. And we're trying to build out and be prepared for that over the next year or two.
Okay. All right. Do we have some other questions for Verizon? I'm just going to throw a quick one at you guys myself. I've been following along here on both staff presentation as well as your own. So if you need to have this small wireless facility on this pole at 16th and Center to ensure you've got adequate coverage for your motorists and those traveling there, well, whether they're walking or driving, I'm assuming that means in other areas of the historic Sherman Hill District, you already have adequate coverage with other towers, et cetera. Because I guess the question that I would have, if we're getting down to really brass tacks on this one specific pole on this one specific corner, are you going to need to do this time and time again in this district or throughout the city? Or is this just one very specific instance where your coverage is weaker or non-existent?
So that's also a really good question. We are trying to build out capacity. We do go where the demands are for the most part. And right now we do see that in this specific location on Sherman Hill, there will be significant capacity demand in the near future. So we're trying to address that as well as interlock this with coverage provided by existing and future locations. As to where exactly those future locations are, we can't speak to future plans or hypotheticals, but I can tell you that we do try to go where demand is. Of course, that's sound business and it's good for our customers, which is what they want. And that's why we're going to this location.
Okay. All right. Okay. Well, I'll make one final round robin here with my colleagues. Anybody else have any questions for Verizon? Okay. All right. Hearing none. For this next part of the hearing, are there any speakers who wish to speak in support of Verizon's request? To be recognized, if you're participating by Zoom, hit the raise hand little picture. If you're participating by phone, hit *9 on your phone keypad, and then staff will recognize you. So, anybody that wants to speak in support? Bert, you see anybody?
I do not see any hands raised.
All right. So anybody in support going once, twice, sold. Okay. All right. Is there anybody that wishes to speak in opposition to the applicant's request? If so, again, same sign, hit the raise hand function in Zoom or *9 on your phone. I will try to take those in order of appearance, but we'll see who Bert wants to recognize. And when we do that, you have up to 5 minutes to present your concerns. You'll need to start by giving, again, both your name and address for the record. And if more than one person wants to speak in opposition, I would encourage you to add comments, certainly one that are relevant, but two that have a different bearing. If you want to just concur with who spoke earlier, you can simply say that. So anybody who wants to speak in opposition?
It appears Martha Green had her hand raised first.
Okay, Martha? And is she by phone?
Yes.
Okay, so Martha,
Okay.
Yeah, you'll have to hit *6, but I think I hear you. Go ahead.
Yeah, got unmuted.
Gotcha.
I have several points to make. Number one is the Sherman Hill Plan, first adopted in 1981 and updated about every 10 years since then, and is adopted by the City Council as part of the city plan, has included since 1981 that one of our objectives is to reduce the number of utilities in the streets. My question for Verizon, you guys have already asked, how many more poles will we get in this neighborhood? Number three, this need for Board of Adjustment action will be required in all local and National Register historic districts within the city. This includes several National Register districts that are north of Grand, as well as Riverbend and Owl's Head. I would also like to point out that by city code, this utilities within the local historic districts, and specifically utility poles, are to be reviewed by the HPC, the Historic Preservation Commission, and that the Iowa Cell Siting Act, because the federal legislation, the Historic Preservation Act of 1966, supersedes the cell siting acts, both nationally, state, and local, that they cannot infringe on the city's right to review this by the local historic district commissions. And therefore, I would like to suggest that they also submit this to the HPC for review. And with that, I'm done.
Any questions for the speaker from the board? Okay, thank you for your well-spoken comments. Is there anybody else who wishes to speak in opposition? Hit the raise hand sign on Zoom or *9 on your phone.
Jack Porter has his hand raised.
All right, Mr. Porter.
Thank you, Mr. President. This is Jack Porter, 815 18th Street. I submitted a letter. I will just not refer to that whole letter, but I will try to emphasize a couple of additional points. I support staff recommendation to deny this application for the reason to try to get Verizon to meet with the neighborhood and explain their future plans. We asked that before and we were denied based on they didn't want to share because of concerns for public information on their plans. I also think that it's very important that it's the historic character of Sherman Hill that's of great interest and value to us who live here. And I think it's as much about the pole as it is about the small wireless facility. We have for many, many years attempted to remove as many of the poles as possible to encourage the vision of our neighborhood, our historic character. Mid-America Energy has been a fabulous partner with us, and I think they should be part of this discussion. And they have been very supportive of our efforts to remove the numerous light poles that were in our neighborhood before the historic streetlights were installed. And without their cooperation and support, that project would not have been possible as far as I'm concerned. But to say this is all Mid-America's pole, they were asked, obviously, by Verizon to install it. I just make that comment. Also, it is very important to me as a former staff member of the State Historic Society of Iowa who reviewed standing structures for the federal Section 106, which is beyond the authority of the Board of Adjustment. They have not applied through the federal FCC as a 106 review. And I would strongly encourage, if the board does not want to act today, that they request that Verizon, number one, submit a 106 plan and also meet with the Sherman Hill neighborhood folks to discuss what our important neighborhood is all about so that they understand what we're trying to accomplish and will also end up being a good corporate citizen for our city.
All right. Very well spoken, Mr. Porter. Anybody have any questions for Jack? Okay, thank you, sir.
Sure.
All right, do I have anybody else to speak in opposition?
Ann Taylor has her hand raised.
Okay, go ahead, Ann.
Okay, can you hear me?
Yes.
Okay, thank you so much. Ann Taylor, and I'm at the Wallace House at 756 16th Street, and I'm a staff member here. And I would, first of all, I appreciate the clarification in terms of the number of poles that are located close to our building. That was not clear to me when I wrote my letter. It seemed like it was just adding another pole, and I understand now the reasoning behind adding a pole, and then because the one at the corner will be removed eventually. So I appreciate that clarification. I would also just want to concur with Martha and Jack's comments about the importance of Sherman Hill as a historic district and the efforts that people who live in this neighborhood and work in this neighborhood have been undergoing for many, many years to try to reduce the number of utility poles. And so certainly that is our long-term goal. And so I would close my comments.
Any questions for the speaker? All right, thank you, Ann. All right, is there anybody else to speak in opposition?
I am not seeing any.
Okay, all right. Okay, so we do have a line item here. Is there anybody that has any general comments? Maybe they don't want to speak for or against, but have a suggestion on this item. We call that neutral. Anybody that wishes to speak from a neutral perspective? Same sign, raise your hand on Zoom or *9 on your phone. All right, nobody there, Bert?
I do not see any.
Okay, does the zoning enforcement officer choose to make any comments?
I do not.
Okay, all right, thank you. Board members, do we have any further questions for our city staff?
Mr. Chair, this is Cindy Smith. I have a question probably for legal, possibly. I know in the past when we've had cell towers presented to us where, you know, they were asking for 80 to 100-foot tower with a big building at the bottom. You know, we've had situations like that where they have the maintenance building surrounded by a fence at the bottom of the pole. And I recall there were some FCC guidelines or requirements that we were bound by or needed to be aware of. I'm not sure how tightly we were bound by those, but I do remember some discussion about that. And I didn't know if this same guidelines or discussion would be pertinent to today's conversation.
I don't believe so, because we're talking about a significantly different type of facility here. I know the big towers that are freestanding that you are thinking of, or at least I believe you're thinking of, and because of the actual physical requirements of those, there are additional considerations. But this, you're looking at the criteria that are laid out on Jason's report. And of those, the one that is of significance is really what the discussion should be focused on.
Yeah, and Cindy,
you.
I recall that well, and a lot of that was more stuff about what issues we can't take into consideration. And I don't think that the issues presented today on either side would have related to any of those kind of out of bounds concerns that the FCC would have ruled on.
Yeah.
Okay. Great, thanks.
Sure.
Other questions for staff? I've just got a real quick one for city staff, and perhaps the appellant can address this as well in their rebuttal. But the appellant is proposing to, it sounds like, remove the pole on the corner, or they'd be agreeable to that, and keep the pole they've installed to put their cell phone equipment on. But would that pole also then carry a Mid-American electric line? So in other words, the pole would be used for more than just the small cell phone equipment of Verizon. Is that correct, staff?
Yeah, this is Jason Van Ness with staff. Yeah, I believe that there's some service lines, both power related and some communication cable data type lines on that that would be carried by the new pole.
Okay. All right. Okay. All right. Well, any other questions for city staff from the board? Okay. All right. Then we'll go ahead. Appellant, you guys can share the stage as much as you'd like, but you've got up to 3 minutes for any closing comments or any rebuttal of any comments, or if you want to address some points or questions that have been presented here. You've got 3 minutes to wrap it up.
Yes, this is Anna Kerselich. Can you hear me?
Yes.
Okay, so I would just take this time to address some of the points that were raised. Verizon did not propose to remove the pole. This was something that came up in the discussions with the city in terms of the pole location. It was the city's request to move the pole further away from the turning radius of the intersection. It is Mid-Am's pole, as noted, and we would be co-locating on that. As far as regulatory requirements related to historic preservation, Verizon has confirmed that it's completed all of its regulatory due diligence and that they are in compliance. I would also note that any sort of Section 106 or historic preservation requirements are not identified in the CUP requirements. So it's not relevant to this appeal. As far as future plans, Verizon doesn't share those because they are not fully developed or because there are competitive reasons for not putting that out there. Verizon did not ask Mid-Am to install the pole. It was already there. And again, if that pole were to be removed for any undergrounding purposes or moving out of the roadway, Verizon would be responsible for removing its equipment. And again, the poles in the alley are just they're not feasible options. We believe we've met all the requirements for the CUP based on the criteria set forth in the city code.
Okay. All right. Thank you very much. Okay. We'll go ahead and does the board have any final questions for Verizon? Okay. All right. Then we'll go ahead and close the public portion. All testimony has been taken. All questions have been asked and answered. So this will be board deliberation between the members now. All right, board members, any thoughts, concerns?
Mr. Chair, this is Cindy Smith. I'll start it off. I don't have a problem with the request. It's a very small footprint. It's going to go on an existing pole. We're not going to be adding poles. It's going to be at the very top. It's a service that people need in this day and age, whether we like it or not. There's going to be cell phone towers, cell phone infrastructure that we're going to need in order for our phones to work efficiently. And then we've already talked about the work at home remote issues for users. And I do understand about utility poles. Even Sherman Hills is a beautiful, wonderful area. And I just wish for the city of Des Moines that we could get rid of all the overhead utility poles. Wouldn't that be a nice dream? But I'm not sure that's going to happen in my lifetime, because I think they're a real eyesore, and they're definitely an eyesore in the neighborhood in which I live, although it's not in a historic area.
Okay. All right. Any other thoughts?
Mr. Chair, this is Lynn Carlson. I have to agree with Cindy's comments there. They have increased in making themselves more discreet than the polls of past. We do require our cell phones pretty much as a service nowadays to get through everything. And yes, I think the city would love to go with underground wiring throughout, because just look what happened with the derecho. I have overhead lines in my neighborhood, and they were out for 8 days because it took so long to repair them. But so I think that overhead poles are going to be there for a while. Since this is at the top, it's unobtrusive. It doesn't have logos all over it and everything. I think it's smaller than a transformer than you see on many of the poles. That I don't think the visual aspect of it is anything that's all that objectionable. These historic homes are living in the modern age. If they want to be without cell service there, then they can do that. But I don't think many people there would want to live without cell service.
Okay. Other thoughts?
Mr. Chair, this is Councilman Gross.
Yes.
I just wanted to share with the board just a small concern. I hear what has been said by Lynn, and what I guess I would say is that it sets a bit of a dangerous precedent here. I feel like moving forward, even though we don't know the future plans of Verizon, it will be looked back on as well. We allowed it to happen here on this instance. So I just wanted to share that concern with the board.
Certainly. I'd like to throw in as well here, all good comments from all parties of interest. When we look at cell phone towers, we've had now 20 years of requirements that conditional use permits are required for installation of this type of stuff. Over the years, the biggest concern has been minimizing the visibility to the fullest extent technologically possible. That has kind of been the underlying thing. And as was mentioned, we used to have 100-foot towers with these big, 8 to 12-foot bases, painted blue or stainless steel, and razor wire and all kinds of stuff around them. Here, our technology is getting better while getting smaller. And I think that would be a benefit to anybody to look at including that. I do have a concern about the proliferation of vertical utilities like poles. Certainly in 1877, when Hoyt Sherman built his mansion, that's why it's called Sherman Hill, there were no poles of any type. There also weren't any automobiles. There weren't any parking lots. There weren't any city stop signs. There weren't any city street signs. Historic preservation is extremely important, and it certainly has parameters. But if we really wanted to free Sherman Hill in time, we'd have to take all those things out too. So if Verizon had proposed installing additional utility poles, which by design or default, that's what's happened here, I would not be in support of that. But as my colleagues have stated, the true heart of the matter, minimizing that visibility to the fullest extent, they're more than going to do that. I'd love to see all the other ones converted like this around the city. Probably not possible. This is for a very localized area. But what I would suggest here is that I don't like seeing 3 big fat telephone poles all right next to one house. I do think that if the one on the corner was eliminated, that opens up that corner, that opens up the view shed, that helps preserve the general character. A few poles down the street side, I think minimizes the in essence the intrusion of the vertical poles. So although I realize Mid-American is the utility owner there of the light poles, obviously they work with Verizon. It would be my proposal that we would recommend the conditional use permit generally with the technology and how it looks as presented by the applicant. However, as one condition, they have to remove that pole that I believe would be then on the southwest corner of the intersection at 16th Center. So I'd want to put that out there as a motion. If there is other conversations the board wants to have, great. Or if there would be a second, I would be happy to entertain that.
Yes.
Was that a second by you, Lynn?
Yes, that was a second by me, but I thought I heard somebody else jumping in first. So, but that's a second by me.
Okay. All right. Well, we'll see how this goes. We've got a motion by Mr. Pins and a second by Lynn Carlson. All those in favor of granting the requested conditional use permit, subject to the condition that the it's built as generally presented and the existing pole right there on the corner is removed per staff concerns. Favor. We'll take roll call for ayes or nays.
Lynn Carlson.
Aye.
Dave Gare.
Aye.
Justin Gross.
Nay.
Marlis Jones.
Nay.
Cindy Smith.
Aye.
Nathan Blake.
Aye.
And Mel Pins.
Aye.
Motion carries 5-2.
Okay. All right. So that concludes that agenda item. I appreciate everybody's time and concern for both where they live, their neighborhood, our city, and serving our citizens. Okay. That'll bring us to then item number 3, a zoning variance request at 4347 Merle Hay Road.
Mr. Chair, members of the commission, Catherine Dostart, planner for the city of Des Moines. And let me just get my presentation up to share with you today. Is that now available? I'll assume that's yes. So to begin, this is, I'm sorry?
There it goes.
Okay, thank you. So as mentioned, this is a zoning variance request for some signage located along Merle Hay Road. The subject property is quite large, and many people will know it because it's also the location of quite a number of businesses in a couple of strip malls, including Aspen Gym, and there's a laundromat in there as well. And then the actual subject property is the tenant bay located on the very north end, known by most as Northern Equipment and Tools. I apologize if I've gotten that name a little bit out of order. Just a little bit of site context from the far side, and then Northern Tool and Equipment. I apologize. And the applicant is asking to do a little bit of change on the signage. They are intending to leave the 2 large, let's say, business signs, and then they obviously have their address signage located here. They are looking to remove the Honda sign that's located here, and then install 2 additional different signs, which I can get to show you in just a moment. So the proposal is to install this new still sign, as well as this parts and services sign. I'll see if I can highlight it a little bit more for you as well. So these are the two signs that they're proposing to install in place of removing the Honda sign that you saw earlier. And they provided us with this image that kind of gives you a little bit better ability to compare what they're doing. Hopefully that's fairly clear. So again, they are looking to remove this sign, and then they would replace it with the still sign in approximately the same location, and then are proposing a second new sign located underneath it. Staff just points out that this is a variance request, and the variance test is typically rather hard to meet. Your criteria are located in the staff recommendation if you have that in front of you. Otherwise, just a little bit about it right here. Hard variances can be granted owing to special conditions where there is an unnecessary hardship. The land in question cannot yield a reasonable return from any use permitted by the regulations. The plight of the owner is due to unique circumstances, not of the owner's own making, and the use to be authorized by the variance will not alter the essential character of the locality of the land in question. Staff has reviewed this over. We have determined that we are recommending denial of these requested variances just simply because the variances themselves are not consistent with the criteria necessary to grant a variance. But we do feel that the applicant has grounds for the maximum relief allowed by type 2 exceptions, which would be 50% over the numerical regulations of the code, meaning that staff is recommending approval of an amended appeal for one sign over the maximum allowed 2 signs, and a zoning exception of 59.17 square feet over the maximum allowed within the area. So that means they could have 3 signs total and a maximum of, I'm afraid I can't do the math on the fly, but I believe it's approximately just under 180 square feet of signage. We did get a few cards back from the notification mailing. As you can see, the Gabus properties are in support of the applicant's request. They didn't give us much in the way of rationale. I would be more than happy to answer any questions that the commission has for me, or the board has for me. I apologize.
Any questions for Catherine?
Okay, this is Cindy. Maybe I'm just not tracking today, but what you're saying is they could keep their northern sign and I'm going to call it their emblem sign, and they could take out the Honda sign and replace it with either the steel sign or part service, but not have 4 signs. They could still have that third sign. And can that third sign be any bigger than it currently is? That's where I got lost.
Oh, my apologies.
No, it's just confusing.
Yep. So they are intending to keep both of their logo emblem signs for the store. And then they are looking to remove the Honda sign. And I apologize. So the sign they are looking to install is, they provided us measurements of 19.5 square feet. And I don't believe we got the Honda sign dimensions exactly. I used a measuring tool, and I think it's approximately 15 square feet is what the Honda sign is. The applicant can probably clarify that better for us. So they are reasonably within the range of what they are allowed to essentially jockey around. Yes. So they could, but the thing is they're asking for 2 additional signs over the 2 that they're allowed. And we're recommending for just 1 over the 2 that are allowed, for a total of 3 rather than a total of 4. Does that clarify?
Yes, that's very helpful. And the third sign, that Honda sign they have, could be a little bit bigger, but you're not allowing all 4 signs. Just, okay, I got it.
Okay.
And and that would make it an exception.
It would make it an exception level. It would make it an exception level for them to go up to approximately just under 180 square feet of total signage, so that they could use it however they would like to, but they're also limited to using it only within 2 signs per the code. Whereas the exception level would grant them the right to go to 3 total signs.
Thank you.
All right. Any other questions for Catherine? Okay. All right. Seeing none, thank you, Catherine. We'll go ahead then and let the appellant present. You've got up to 10 minutes to present your reasoning for your appeal. We just need your name, business address for the record, and you can go from there.
Right. It appears Sarah Pendergast is prepared to speak.
Yes, from Assistant Construction Manager of Northern Tool and Equipment. Are you guys able to hear me?
Yes.
Okay, thank you. So yes, we would like to replace our steel, the current Honda sign that we have in our building with steel, as steel is a new vendor that we are selling in our stores that is requiring us to put the sign on our building. And with that requirement in remodeling the store, we had invested $400,000 worth of work in this recent remodel that we're just finishing up. That is adding a parts room and service shop, a service room area in the sales that we would like to share with our customers, that we have then added this space to our building, which is why we want to add the parts and service repair sign below the steel sign. We were hoping with the Honda sign being existing, and it is approximately 20 square feet, similar to the same size of what steel will be, that the only issue was the parts and service repair that we were hoping to be approved.
Okay. Anything else you'd like to add, or ready for some questions?
I guess I have one other coworker with me, Scott Grossman. Not sure if he has others to add, but I am open to questions.
Sure. Scott, you want to add anything?
Yes. Hi, this is Scott Grossman. Can you all hear me?
Yes. Yes.
Oh, great. Thank you. Thank you for hosting us today. We appreciate it. So the 2 signs are specifically related to helping the community understand that we offer the services for our parts and service and repair for the parts room that we constructed during the remodel, as well as Sarah mentioned, steel is a very well-known vendor and provider of equipment to do-it-yourselfers and professionals all over the country, and their requirement to have their products sold in our stores is to have a sign on the building that says we have steel in it. So that's really the reasoning for the 2 signs. If we didn't carry the steel line, we wouldn't have applied for this variance, because we would have just put the parts and service sign on the building and removed the Honda sign, and we would have been under the required allowance. So again, we appreciate you all hosting us today. So thank you very much.
Okay. All right. Thank you, Scott. Any questions that the board has for the applicant?
Yeah, this is Nathan Blake. I've got a question. The staff presentation alluded to this. In their recommendation, they don't believe that the criteria for a variance has been met here. And if you're kind of aware of what the criteria is, it is rather strict. And one of the component basically is you need to establish a necessary hardship. There are 3 components to that, one of which is, I think, in my tenure here, the most difficult to attain, and that is the first one, which is, you can see kind of on the screen there, the land in question cannot yield a reasonable return from any use permitted by the regulations of the district in which the land is located. I hesitate to continue reading that everyone can read, but suffice it to say, it's not enough to just show that it's going to have a detrimental hit on something that's your profits or something like that, but that it's at actually no reasonable return from any use permitted. My general feeling is that it is the 1 out of a million signs that would hit this. But I'm interested in hearing, because I didn't feel like I heard in the presentation an argument that even attempts to address this particular requirement. So I'm interested in hearing how you think that it hits this requirement. Thanks.
Yeah, if the applicant would like to respond, go ahead.
Yes, this is Scott from Northern Tone Equipment. I don't believe that sign specifically meets that requirement. We've been told by our customer base in the Des Moines area that they would like to see us carry this product. Along with the product, again, the requirement from Steel is to install a sign on the building. And while we also sell their product, we also service their product. So we invested in constructing a parts and service area in the store to be able to service the equipment that we sell, including the Steel product line. So that's our reason for applying for the variance.
Okay. All right, other questions for the applicant? Okay, all right. Well, seeing no questions, we'll go to if there's anybody that wishes to speak in support of the applicant's request. We can see if there's anybody in the audience that would like to speak in support. And to do so through Zoom, hit the raise your hand icon to be recognized. By phone, hit *9 on your phone keypad, and we'll have our host recognize you.
Do not see any.
Okay. All right. Going once, going twice for support. Okay. Do we have anybody that wishes to speak in opposition to the applicant's request? Same sign to be recognized.
It does not appear so.
Okay. And, just in case there's a neutral country out there that would just like to share some general comments related to the request, anybody that wishes to speak in that? I'm assuming that's a no, Bert.
I don't see any.
Okay. All right. Zoning enforcement officer, anything you would like to add?
Yes, Chair, members of the board, this is Sue Ann Donovan, the zoning enforcement officer for the city of Des Moines. I do not believe that they've met the variance test. If the board should decide to allow 3 signs, it would seem that they could put the Steel sign, parts and service into one sign area. Perhaps the word Steel would be smaller, but you could incorporate maybe another design to get what you want. But I don't believe they've met the variance test for the 4 signs or the increased area of signage.
All righty. Board members, do you have any questions for Sue Ann or city staff? Okay.
Sorry for the delay. I've got one question.
Sure, go ahead.
They were mentioning when they're doing that, that the address numbers on there, are the address numbers considered a sign or not?
No.
No, it is
they
not.
don't.
No.
Chair, members of the board, zoning enforcement officer, this is Sue Ann Donovan. No, those don't count toward earned signage.
Okay.
Thank you.
All right. Okay, therein, appellant, you've got up to 3 minutes if you would like to give any final closing comments. If you don't want to, you don't have to, but we'll give you the floor if you'd like it. anything you want to add, or does anybody want to be recognized there? This is for anybody with Northern Tool. Any closing comments you'd like to give on your own behalf?
It appears Scott has some.
Okay, go ahead.
Sorry, y'all, I was trying to get unmuted there. So I wanted to thank you for your time today. Again, we just wanted to reiterate that we just invested over $400,000 into the store to remodel it to better it for the community shopping experience. And we're just looking for consideration from the city to allow us this exception to these these two signs on the building. So we appreciate your time today. Thank you very much.
You bet. Thank you. Okay, we'll close public portion and go to board deliberation. I do want to kick this one off just with to maybe lead off in a positive note here, generally speaking. I've shopped at Northern Tool for many, many years. Bought 3 mini bikes there, parts, trailers, tires, you name it. I'm glad to know that you've invested in expanding the store. Business must be doing well. I'm pleased to have you part of our city and our community as a retailer. Within that, any retailer would love to advertise and have as many signs as possible. There's no doubt. But there also has to be a function of community character within that. So in looking at that, this site does sit pretty far off the street. So if the folks at Northern think that they're going to be grabbing street traffic with the brand name of the equipment they carry, that's probably mistaken. I don't think that was their argument. But therein, just because your vendor or the line of tools you carry, quote, requires you to have signage, that does not usurp or trump any regulatory authorities for community character. If so, I think that Hy-Vee food stores would have Kellogg's and Anderson Erickson pasted all over their storefronts. They can't do that. So I think there needs to be some reasonable thing that would let you do what you're doing and doing it well. But the variance test is a strong one, as our vice chairman pointed out. I'd like to hear what my colleagues think, but I would certainly be in support of something at the exception level, but not at the variance level.
Mr. Chair, this is Cindy Smith. I would concur that the exception level makes more sense for this. And I would also agree that Northern is a great place. My husband continually goes there, especially after Duretto. He went there and bought a chainsaw. That was the first place he headed. So oftentimes they're a top on our list, and it's a great store.
Mm-hmm. Anyone else?
Mr. Chair, this is Justin Gross. I would concur with the statements already made, but I also would encourage the applicant to consider the idea that was brought forth by Sue Ann Donovan. It sounds like it's something that could be considered. They could and have kind of both of those two ideas maybe into one sign. So I would be for the amended for the type 2 zoning exception. Thank you.
All right. Thank you, Justin. Anyone else? Okay. I think what I'll do is I'll just go ahead, maybe just come in full circle here. I'm going to make a motion, kind of a dual motion here. I'll make a motion to deny the requested zoning variances, but to grant approval of an amended appeal for a type 2 zoning exception to allow for the 1 wall sign over the maximum allowed 2, and the type 2 zoning exception for the square footage as noted, so long as they comply with the sign permit ordinances. So basically, I'm making a motion for the staff recommendation. Would there be a second for that?
I'll second, Mr. Chair. This is Cindy.
All right, so motion by Chairman Pinn, second by Cindy Smith. All those in favor, or aye or nay, we'll take a roll call vote.
Dave Gare.
Aye.
Justin Gross.
Aye.
Marlis Jones. Marlis Jones.
Aye.
Okay.
Cindy Smith.
Aye.
Nathan Blake.
Aye.
Lynn Carlson.
Aye.
And Mel Pins.
Aye.
Motion carries 7-0.
Okay. All right. Well, again, I wish you guys well with your business up there, and please work with staff on any current or future needs you've got. Okay, that'll bring us then to item number 4, a zoning variance request at 100 Army Post Road.
Mr. Chair, members of the board, Eric Lundy, Senior City Planner. Item 4 is at the intersection of where South Union becomes Chaffee Road and where East and West Army Post diverge. It's in the southwest corner. The applicant is requesting 2 variances to allow the retention of an existing pole sign that was installed at the time it was actually a large supermarket and has been reused in that time. The triggering event here is the change of usage of the building. While there's some office being retained by the new owner or the new purchaser, Des Moines Area Religious Council, they are also planning to consolidate other aspects of their operation, including their warehousing and distribution of food pantry commodities here as well. So that's a change of use, and in the code, the triggering element is when there's a site plan required by the change of use that triggers the removal of any existing pole signs. So they certainly earn monument signs on the property. If they wish to, they actually have 2 frontages. They could earn up to 200 square feet of a monument sign, either of the 8-foot tall variety when it's closer than 25 feet, or going taller up to 15 feet when it's outside that 25 feet from the street front property line on both Army Post Road and Chaffee Road. So they do earn signage. They're not obligated to have signage in any event. They can certainly have signage just on the building if they want, or no signage at all, which the arguments you're going to hear from them is that the visibility of their location is important. So I'm assuming that they're needing signage for that purpose, but they do earn signage under the new code provisions. So the code's intent really is to trigger that attrition of monument signs as investment is made. So, we welcome their investment being made to the property as well. And that's actually under the intent of the code of why this is actually requiring the removal of the monument sign. So that's kind of my opening statement there. But the location, if you're not aware of it, the existing Fort Des Moines is still a little bit to the east here, and then the Fort Des Moines Museum directly across Chaffee Road to the east. There's a strip center to the west, multifamily housing to the south, and then smaller commercial on the north side of Army Post Road. It is a signalized intersection. So here's a picture of the sign in front of the building, which is under the modifications and alterations they're proposing for their use. One of the things you see in the foreground there is a part of the old gateway to the north entrance to the fort. Actually, since they submitted their application, I believe the archway was damaged in some fashion, and hopefully will get restored over time here. Then looking kind of more to the northeast is this photo, again showing probably a 1980s era monument sign or a pylon sign, which we call a pole sign by definition in our ordinance. And again, you can see the gate elements here. The location is right in this northeast part of the site. Relative to their parking, this is a sketch that was provided with their application to show that location. Again, they have over 200 feet of lineal frontage on both Chaffee Road and Army Post Road to max out the freestanding sign earnings for a sign on each frontage in the form of a monument sign. This is their submitted as part of their application to show the dimensions that we're talking about here. And again, there's where you see the arch actually intact in that photo. They made their application. William C. Knapp LC is actually the property owner currently, unless that has changed hands since the application was made. In the staff report, you will see the chart from the code that shows the permitted sign types and the earnings. Then you'll also see the applicable requirements for what a monument sign is required to have. It speaks to the base and what's required for the height, depending on how far it's set back. And it talks to the number that it's allowed in the EX zoning. And then the triggering provision for the loss of the non-conforming status is also included for the board's consideration. The criteria, again, you discussed them with the previous item, but for variances, we do have to prove the 3 criteria, which is the hardship, the unnecessary hardship test is what we call it. The land, if we don't grant this variance, can the land yield a reasonable return if it's not granted? Is this a situation of not of their own making, and then will it negatively alter the essential character, or should it be within? I think you would have to find in compliance with all 3 of those provisions in order to determine that a variance is warranted. Then staff also included the provisions for consideration of the type 2 exception, which would allow a lighter test here for the practical difficulties. Certainly the application submitted, and you're going to hear from the appellant that they definitely have challenges to getting the visibility, and their clientele is a challenge clientele who really needs to find this location to get their service that they need. And so they've definitely made a case for this need to have this visibility, and whether that's a practical matter when we require this sign to be removed, is that taking away their ability to achieve that? And so I think there are some practical hurdles here for them, definitely based on this. Also, the essential character is involved with granting of the type 2 exceptions. The other test here is the feasibility of the alternate means, which, so if you can consider the comparison of the savings of the return from the savings of using the existing pole sign versus the cost of putting up new signs, for example, although the exception is only going to allow the new signs, so I'm not sure that really plays into it much. But then the requested exception will meet all 5 of those things in terms of meeting the character and not impairing light. I don't believe staff thinks that this request would at all not meet those 5 elements in Part D there. And then it has to be within the applicable district regulations, which again, we would be applying in our recommendation for an exception in this case. There's staff put forward the information provided in the application by the applicant as to their situation and challenges and what they're wanting to do moving forward, and what their argument is for retaining the existing pole sign. So that's in the additional information section. The other thing is this entire project did require rezoning recently over the summer. by the city council to allow this facility to be located here where they're consolidating their operations, including office and their food pantry warehouse, basically, in the same location. Any sign change of the existing sign or any new sign would have to have a permit by the Permit and Development Center. Staff is going to recommend denial because we don't believe that this is able to demonstrate meeting those unnecessary hardship criteria for the variance test. We believe there is a practical alternative that would achieve the same thing. We do recognize that that would come at a cost that's beyond what they were proposing to build new signs. You're probably going to see some examples of how they view that would be done. And I would argue that if they do go with a 22-foot tall, 22 and a half foot tall sign, we certainly don't require them to make all of that sign the base. The base would only need to be 25% of the height of the sign. They could use other material extending up from that as long as the base and the support is the same width as the actual sign face. The sign face, again, they're going to max out a 200 square foot sign area on each of those sides, actually. So they would have a fairly substantial ability to provide a visible sign, even if they pulled that 25 feet back from the frontage. And certainly a 200 square foot sign at an 8-foot height closer to the street would also be fairly visible, especially if you get one on each frontage, which they would do, which they would have the ability to do. Again, cost is going to be a factor there one way or the other. I'm sure they didn't anticipate this as part of their cost of their overall project when they started putting it together. So staff does believe that the variance test isn't met, so the variances should be denied. However, we could support the argument that this does meet that practical difficulty test. We would want whatever signs were installed to be in character. We believe that the historic limestone entrance gate is a good context for them to look at in terms of a base material, trying to either match or look at something that's compatible to that. And as well as the building itself that they're going to be occupying. Again, in this situation, certainly they don't need to make something massive and large either if they don't choose to. This is a question of what's necessary for the visibility that they need. And, you know, if they're going to max it out at 200 square feet and a 22.5 foot sign, that is going to be a large monument sign, but again, it should be visible. And there's things that they can do to not make it look too massive, especially if they keep the height of the base at the 25% and use some kind of other material for that support portion that would match the building and get up to the face. So from that standpoint, I guess staff is recommending denial, but approval of the variance or a type 2 exception, subject to getting a permit. We do want to make sure that if they do choose a sign over 8 feet in height, that it would be set back at least 25 feet, then to go up to that 22.5 feet with the exception. There was one card received from the neighborhood association to the north, for Des Moines neighborhood in favor. That won't show up on the map. They get it mailed because their neighborhood area is within the 250 feet. Otherwise, we didn't get any other response cards. And then I do have materials for the applicant to use that they sent for support of their presentation. Are there any questions from staff here?
Mr. Chair, this is Justin Gross. I have a question for Eric. Eric,
I think part of your report was that the property recently was rezoned EX mixed use district.
Correct.
As part of that, are they required to put in some trees and landscaping there on Army Post?
Yes, so there's a site plan that's part of their, getting occupancy of that building. That's actually what's triggered the removal of the sign. So when the site plan came about due to the change of use of the building, that is the element that triggered the removal of the pole sign. And so they will have to do things with the parking area for landscaping and so forth as part of the new Chapter 135 requirements, and that's been submitted, I believe, and is under review, and that could be approved independently of your action here today. But that in itself triggers the removal of the pole sign.
Sure. I guess furthermore, I guess my question is, as part of that site plan, though, there will be, there's going to be trees that are all along that property line, right? I think part of their argument is that when trees are going to be planted, it's going to be hard to see any signage.
So our sign requirements are designed to be compatible with the other standards that we have in place, such as placement of landscaping along, frontage buffers and things like that. So it's contemplated that, signs will be located in a way to, not be impacted as much by the landscaping. Otherwise, and on every site, they're going to be working against each other. So I think that's a tough argument. If we were pinpointing it to a certain place and we knew there was existing trees that were going to block it, I think that might be a reasonable argument. But people be asking for waiver of landscaping all the time because people driving by can't see through it to see the front of the store or something like that. So where's the balance? And that's, we feel like our standards in our Chapter 135 are in balance with our signage allowances. And certainly if there was something unusual, I think that should be able to be taken into consideration. But I don't see any amount of landscaping here, unless there's some expectation that this be seen in quite a ways in the distance. I don't see that being something that's really that much of an impediment.
Thank you.
I don't have anything further if there's no other questions.
Okay. Any other questions for Eric? Okay. All right. Thank you, Eric. All right. Applicant or representative of the applicant, you've got up to 10 minutes to present your case for your appeal. So we'll turn it over to you.
Hi, this is Matt Unger. I am the CEO for the Des Moines Area Religious Council, DMARC, 1435 Mulberry Street. And if you could also unmute Doug Saltzgaver, our project engineer, will both be speaking on behalf of the appeal here. As noted by the staff, the big concern for us with this is twofold, really. Visibility and the ability for those who are seeking our assistance to be able to find us, which is fairly critical for those folks who have a food need in the community, which particularly in the more recent history has been ballooning. And then COVID really had a gigantic impact on that as well. So one, the ability for folks to find us, and to that end, this existing sign was sort of an attractive selling point of choosing this location and coming into the purchase agreement that we have for the location. The other pretty serious concern for us is cost. As a nonprofit organization and a charitable organization that is working to meet human needs, it is very difficult to put together funds to do a project like this at all. But to make the argument to those that would fund us to pay the cost of removing a sign to replace it with a similarly sized sign that's just in a little bit different of a look. It gets to be a very difficult sell. As a charitable giver myself, I know when I donate to organizations, I want to know that that money is going towards things that are going to really further the programming. And while we can make the argument that this is a critical need for us so that folks can find us, the cost we're going to have to incur to do that, it makes the sale much tougher. I respect and understand the arguments being made by staff, but the sort of proposed alternative, there are also some concerns with where exactly we'd be able to put that on site, given some other pieces that are in that area that Doug will speak to. Doug, do you want to talk about the difference between the two signs and some of the problems that poses to go the alternate route?
Certainly. If someone could pull up the PDF I sent for sign existing allowed. There we go. Thank you. On the left is the existing pole sign that shows the rough dimensions, basically a T shape. And what staff is indicating that we could construct up to 22.5 feet high, and I put on a sign face of 25 feet wide. So we couldn't go as high by a little less than 3 feet, but we can go wider, and it's much more massive than what the existing sign is. We would be set back, however, though 25 feet as staff had indicated. And now if you could switch over to the other PDF I sent, sign layout, please. Thank you. That was a good observation or question by one of the board members about trees. This does not show the landscaping, but the islands you see out in the existing parking lot, those are not there now. We have to cut those in, all but about 2 of them, to install parking lot trees. And then also we're putting in 12 trees along Army Post Road, along with a 3-foot high ornamental fence and a continuous row of shrubs across there to form a continuous hedge. So if that's going to get to 3 to 4 feet tall. As pointed out, all the trees that are going to be planted in the parking lot right now, they may not be an issue for viewing any signage that could be put on the building, but in 10 plus years, as those trees get taller and gain canopy spread, it is going to be more difficult to see the building. We looked at 2 potential locations for installing such a tall monument sign. One is at the corner of Army Post Road and Chaffee Road, very near to where the existing pole sign is. I've indicated that on this drawing. We'd have to lose a couple parking stalls, which parking is not an overall issue for us on this site, surprisingly, compared to most developments. However, it would be behind that limestone entrance feature. So we also looked at could we place it over to the west by that entrance. And again, we'd have to take out several parking stalls to do that to get the 25-foot setback. And directly west of where I'm showing that, there is an existing sign that's about 30 feet tall right now that lists businesses in that existing shopping center. So if you could turn to one of the photos I sent, the eastbound, I believe, there we go, thank you. So looking eastbound out in front of the strip center there, you can see the sign they currently have. And any monument sign that we would be placing would basically end up right behind that. So until you're about at the driveway ready to enter, you wouldn't see our signage. Thank you. And yes, that's the entrance feature. Putting a smaller or lower sign closer to the street right-of-way of Army Post, we would be, again, competing much more with that entrance feature there. And again, we're thinking that since staff would allow us to put in a sign that would be actually much more massive than what we're seeing here, we'd have to have the expense of tearing this down and then the expense of putting up another sign. And I'm sure Matt doesn't want to be operating this facility and someone come up and ask him to help them with the services they provide, and Matt has to tell them, no, we can't do that today, but we would like you to go out into our parking lot and enjoy this new monument sign we have that we spent in excess of probably $40,000 to construct. So with that, I don't have anything more unless someone has questions or Matt wants to add anything. Thank you.
Okay, I'd say based on our time constraints here, you guys have made your presentation. Board members, do you have any questions for the applicant?
Mr. Chair, I do. This is Lynn Carlson. You mentioned $40,000. Have you had estimates done for the removal and installation of a new sign, or is this just a pulled from the air figure?
No, we've not had a estimate that I'm aware of, unless Matt hasn't shared it with me. But yeah, it's more of a poke in the air. I've been on other projects where I've seen monument signs that are in the 6 to 8 foot tall and 12-foot length run in the $25,000 range. So I know the foundation for a taller sign is going to be more expensive, and also just there's more material to put into a taller sign. So I think it's a reasonable estimate that it'd be somewhere in the neighborhood of $40,000 for a new sign of what I was indicating. So,
okay. All right. Other questions? Okay, gentlemen, thank you for your presentations.
Thank you.
Thank you.
All right, we'll see if there's anybody in the audience who wishes to speak in support of the applicant's request. Just hit the raise hand symbol in Zoom or hit *9 on your phone's keypad, and then we'll have staff look for you and recognize you. Anybody speak in support?
I am not seeing any.
Okay. Anybody to speak in opposition? Same sign.
Still not seeing any.
Okay. Is there a big crowd that's maybe in the middle on this one? Any neutral comments? Okay. Zoning enforcement officer, do you have any comments?
Chair, members of the board, Sue Ann Donovan, zoning enforcement officer for the city. Yes, I have some comments. I have listened to the presentation, and listened to the city's presentation, and I do not believe that this sign to remain meets the variance test in any way. There is ways to meet a reasonable return. I know it's a nonprofit. People who wish to access their services will find the property if they wish to with a smaller sign. If they don't want to use the exception and build a large monument sign, they can certainly put in a lower monument sign that is in more keeping with the property and maybe closer to the street for visibility. I don't believe they've met the test for a variance. I think that sign is sort of a poster child for a sign that the city would want to be removed and have a nicer, cleaner monument sign put in its place. And so therefore I argue even if they get the exception, they don't have to build to that level. They can build something more in keeping with their budget. Just because they're a nonprofit doesn't mean that they get a special consideration on a variance. So I would argue that the sign needs to come down. They can put up a monument sign that's more in keeping with budget and scale and not use the exception to the level it's granted. So, thank you.
All right. Any questions for Sue Ann or staff from the board? Okay. All right. Seeing none, appellant, we'll give you another 3 minutes if you've got any closing comments or any final thoughts you'd like to add. You don't have to comment. You don't have to take all three, but I'll give it to you.
This is Doug Saltzgaver again. I guess I didn't give my address and company, Engineering Resource Group, 2413 Grand Avenue, Des Moines. I should have been scolded for that. Anyway, yeah, the going with the lower sign and pulling it closer to the right-of-way of Army Post Road, that's an option. But then again, we start competing with the landscaping out front. We've got the street trees we've got to put in at 30 feet on center. We've got the ornamental fence and the hedge. And so we do get closer, but we've got to go down in height. And then again, we're competing with more landscaping, and that's regardless of which corner we're at. And if we go to the northeast corner, we're also competing with that limestone entrance feature. So just thought I'd bring that up.
Yeah.
The only other thing I would rebut, and this is Matt Unger again, is that I appreciate where you're coming from, but just because someone is looking for and in need of the service, if they can't find it, doesn't mean they will find it. Most of the folks we serve are bouncing between service appointment and trying to work and trying to collect a number of different pieces of assistance. And there's a finite amount of time to do that. And if they can't find it, they will just go without food. So I appreciate the sentiment, but I disagree.
Mm-hmm. Okay. All right. Okay, we'll close the public portion and go to board deliberation. Do we have some thoughts from the members?
To Chair Lynn Carlson here. You know, they're talking about expenses and they really don't have any proof on it. And I would really like to see if you're going to use that as an argument to have a couple of estimates, I guess.
Right.
It wouldn't be too hard to get a couple of estimates on that. But the whole thing with the monument signs is we are looking to clean up the landscape of the city, make things look nicer. And pole signs are going to be a sign. It shows that a building is older. And I just don't think they've met the requirement for the variance. But if I'm inclined to go with the exception level. And again, they don't have to go that high if they don't want to save money. A lot of people, yes, they are going between appointments, but most people I know do have their phones, which have a GPS function, which should get in there. Mm-hmm. So those are my thoughts.
Okay. Other thoughts? I might throw in here, all of us obviously live in Des Moines. Most of us get around town. I certainly do. I live 2 blocks from this location. I drive by this location anywhere from 2 to 4 times a day. This location was the original Albertsons grocery store. So that explains the layout, functionality, and the original pole sign base that's there. The Albertson chain wasn't here very long. For a good part of the last 15 years, that site had sat vacant for quite a bit of time. Yes, there was a Medicaid office in there for a while, but this property, based on size and scope, it was difficult to find the right kind of use for it. So I'm pleased that these folks are in there, but that did require a rezoning request on this corridor. In looking at the character of the corridor and now this use for the food pantry, the idea that we still need to have a sign from an old grocery store chain out front, I just don't get it. This is the largest single freestanding building on the Army Post corridor. Take Southridge Mall out of the picture, that's multi-tenant. This largest freestanding building is one of the largest parking lots. It sits at a signalized intersection. The building itself has an extremely large vertical facade. That's where Albertsons had their sign before. I don't think we need to make people play hide and seek to find any kind of service, but I also don't think that we need a pole sign that is certainly now considered illegal and non-conforming. Some examples were noted of some other businesses that have pole signs. Those are businesses that were developed in the late 70s, early 80s. Army Post Road at one time was just that. It was the road to the Army Post. For 60 years, it was the Highway 5 alignment. A lot of the development in this area happened before the city annexed this area. So there's been a lot of incongruent growth down there. But in the last decade, we've had plenty of new developments that have complied with our sign ordinance, including installing a monument sign. Across the street, there's an ethnic grocery store in an old come and go. Meets all the requirements. Got a local financial advisor. Across the street, doesn't have a pole sign. 2 new gas stations to the west and a new car wash, all monument sign. So I don't see the hardship here. We're not meeting the variance test at all. Frankly, I'm not even in support of recommending an amended appeal at an exception level. They'd be allowed to have a 15-foot tall sign. They should be able to position it somewhere on the property for visibility. So just kind of wanted to throw that one in on a local level. So if there's any other comments or anybody has a motion.
Mr. Chair, this is Justin Gross.
Go ahead.
I just wanted to comment that DMARC is a fantastic organization,
Yes.
and they do good work for our community. However, the city council has made it a priority to eliminate these pole signs, and over time, if there's any triggering events, and of course with the rezoning and the amended plan there, that's the triggering events. I would like to make a motion, Chair and members, that we deny the variance, but that we approve the exception, type 2 exception.
I'll second that, Mr. Chair. This is Cindy Smith.
Okay, so we've got a motion by Justin and a second by Cindy to deny the variance, but to grant the recommended amended appeal as stated in the staff recommendation. So we'll have our proctor take roll call here for voting.
Justin Gross.
Aye.
Marlis Jones.
Aye.
Cindy Smith.
Aye.
Nathan Blake.
Aye.
Lynn Carlson.
Aye.
Dave Gare.
Aye.
And Mel Pins.
I'm going to vote nay.
Motion carries 6-1.
Okay. All right. That decision order will be ready toward the first part of next week for you all. If you need to then discuss with staff further any issues related to the permissions granted and how that works with your sign permit. Okay, that'll take us to item number 5, which is the reconsideration of a conditional use permit. And our format for this agenda item in the hearing will be slightly different than our standard items we've had thus far, as this is a request for hearing being brought by the zoning enforcement officer. So our process is just a little different. We're going to put that up on the screen for everybody to see here. So we'll start off with the zoning enforcement officer's presentation, and we'll give Sue Ann up to 10 minutes.
Are we ready to start?
Yes, we are.
So, Chair, members of the board, this is Sue Ann Donovan. I'm the zoning enforcement officer for the city of Des Moines. Bert, are you going to go through the slides for me?
Yeah, I will. Yep.
Okay, thank you. So we are here today to discuss the conditional use approval for the bar at 525 East Grand. It has recently been leased to a new business, and we've had a number of complaints over the summer regarding the noise and some other issues that have arisen since the bar has opened up that have to do with the patrons of that bar. So on August 27th, 2020, I did send a letter to the owner of the bar and the owner of the property, telling them that they would be appearing before the Board of Adjustment today to discuss the conditional use approval. So one of the things that they have to comply with as part of the conditional use approval is to not become a nuisance. And that ordinance is contained in Chapter 42, Section 348 of the Municipal Code. And it states the business and operation or maintenance of which adversely impact nearby residents or commercial uses and which jeopardizes or endangers the public health or safety or the health or safety of persons residing or working on the premises or in the surrounding area. B, has resulted in or facilitated any of the following activities: disturbance of the peace, illegal drug activity, including sales or possession thereof, public drunkenness, drinking in public, harassment of passerbys, gambling, prostitution, sale of stolen goods, public urination, theft, assault, batteries, acts of vandalism, excessive littering, illegal parking, excessive noise, particularly between the hours of 11 p.m. and 7 a.m., noxious smells or fumes, traffic violations, or police detention, citations, arrests, or violates any other section of this article or any other city, state, or federal regulations, ordinances, or statute. The complaints from the neighbors and the people in and around the business are particularly concerned with disturbance of the peace, excessive littering, illegal parking, excessive noise. That would be the bulk of the complaints that we have gotten. A little history. August 25th of 2010, the property was given a conditional use approval where it had certain things it needed to comply with regarding the rooftop patio, liquor license, and then it had to do with noise control. We came back to the board October 23rd of 2019 to discuss that previous businesses' activities in the bar, especially the rooftop portion, at which time it was determined that they had been putting music through external speakers in violation of the conditional use permit. They agreed not to do that. I believe that the conditional use approval continued, but they needed to comply with no music on the amplified music on the outside patio. So we go through these are the staff recs, talks about the conditional use approval and what is required for the business. What we're asking for is consideration of the conditional use approval by the board due to the nuisance allegations from the neighbors that have come up. We have a card that says from Tim Ripma, the tenant has not been a good neighbor and has caused many issues. We have a statement from a realty company at 604 East Grand stating that they're in support. We have emails from Brittany French where she has complained about this business Brittany has now told me that they're moving from East Village due to the continued noise and violations at this property. Here is a picture where it's showing illegal parking of motorcycles in a loading zone. The next picture shows a large gathering on the patio, rooftop patio, which created noise and a violation for the neighbors. And then we also have some videos and some audios that Bert will play for us to show the level of disturbance from this business.
Hopefully you're able to hear the audio.
Couldn't hear it real good, but there was some noise coming across the street from the patio.
Large crowd gathered. 1:45, music still playing. Large crowd gathered outside. Stick my phone out the window so you can hear music.
I believe that was showing garbage she had picked up from the street. And just in the transition here, do we have some more audio or video? Yeah, okay.
That was the last one.
Okay. That sounds like a Dodge. That sounds like a Dodge Challenger burnout. Chair, members of the board, Sue Ann Donovan again. We did, staff and council members met with the owner and their attorney. We were trying to figure out a way that we could work together so that this would not have to come back to the board. We received complaints after that meeting I don't know if a good neighbor agreement at this point would be in order, or some other way that we can get an assurance that the bar will attempt to be a better neighbor. What PD pointed out was that they are responsible under ordinance for their patrons, and that they had asked them to make sure that they were helping inform people that the motorcycle noise needed to be kept down and that patrons shouldn't be in the street, and to keep the music down on the patio. So that would be, if you would agree to that, another solution rather than taking their conditional use approval away. Other than that, staff doesn't know how to address the continued complaints that this business is bringing forward to us.
Okay. All right. Sue Ann, anything else you want to add, or are you ready for some?
No, thank you.
Okay, board members, we have questions for Sue Ann. All right, and we can come back to you later on that as well. All right, I'll tell you what, let's go ahead and hear from the property owner or the business operator, holder of the conditional use permit. I just need your name and address. You've got up to 10 minutes to present your reasoning of why we should not revoke your conditional use permit.
Hello, this is Matthew Gilbert, and I am attorney for Mr. Larry Mason, address 525 East Grand Avenue, and we would like the property owner to begin here, and I'll jump in and give Mr. Larry Mason an opportunity to share his side of the story as well.
Okay, this is Nancy Wilson. I just want to make sure I have 5 minutes of time here for speaking. Is that
well,
if their 10 minutes of time?
If you're representing the operation and you're speaking as the person who's trying to defend the conditional use permit and not having us revoke it, you can have up to 10 minutes to address the board.
She is representing the property. Facts go back to 2010. This is Matthew again. Go ahead, Nancy. Okay. I'll jump in.
All right. Good afternoon. I'm Nancy Wilson. I live at 901 Walker Street. I'm co-owner of 525 East Grand and was owner of the businesses that occupied the building from 2005 until 2017. To clarify, our first notification specified, actually, we'll just skip that. I need to note that as landlords, we're not living on site. We aren't even aware of issues that happen unless we're notified of them and given the opportunity to address them with our tenants as they occur. With this tenant, we've been notified exactly twice. The first time was regarding a meeting outlining our tenants' responsibilities, which they have addressed and continue to address since that time. And the second time was notification about this hearing. On August 27th, we were copied on a letter to our tenant from the city stating the city has received numerous complaints regarding 525 East Grand second floor coming from bands with sound systems. Not only has our current tenant not had a band on the second floor ever, they haven't even had a band on the first floor. This tenant was set to open in April, but due to the lockdown, ended up opening in June of this year. So any problems prior to that date have nothing to do with them. Per your words on the notice, the decision granting the CUP to be brought back to the board if the business showed a pattern and practice of being a nuisance. Per your words, problems caused by a prior tenant should not be taken into consideration here. Also in your words, on the decision and order for the CUP for the rooftop, it said, this is an appropriate location for the proposed use as it is located in the downtown. Nearby residents should expect the level of impact created by businesses selling liquor as part of the mixed-use environment of the downtown. And those are city words. Those aren't my words.
The current
Where are
tenant.
those city words at? Can you show those, or that's what you're quoting?
I can. When Matthew's speaking, I'll find those. Is that okay?
Okay.
All right. Also, your words on the decision, or sorry, the current tenant is a brand new business and has some kinks to work out, but every new business in the city of Des Moines should really be worried if it takes this little to kill them in less than 4 months of being open. In the meantime, they're fighting for all the business they can get and dealing with the pandemic closures and restrictions unprecedented in our lifetimes. This truly appears to have become a case of harassment based on this proposal is based on complaints, not actual violations. The city should be working with businesses to rectify any problems. The CUP allows for 100% subjective application of the laws and needs to be measurable instead. Being on the East Village board for 5 years, I know that other businesses in the area over time have had many, many more complaints, but the city worked with them to resolve issues instead of threatening to shut them down at each turn. This property is being held to a much higher standard than any other property in this district. Staff member threatened that if there was one more complaint, not a violation, but a complaint, that she would recommend the revocation. I just feel this is moving way too fast when people's hearts, souls, and livelihoods are at stake and should be reviewed, understanding the gravity of the actions being requested here. Looking at the evidence presented, it appears that the recordings may have been made in 2019. Based on the labels of the files, it says La Hacienda. They vacated the building in January. It appears they haven't attempted to verify that these apply to the current tenant. Negative cards came from people that don't live on the block. Apparently, the mail service wasn't able to get our card that was not in favor to you in time. One of the videos presented proves that the noise was coming from the motorcycles as they left and not the bar, because as the motorcycles left, there was no longer the noise, the music playing. I would assume that illegal parking is a city issue and not a business issue. We don't even know that those motorcycles were customers of their establishment. There's no proof that his business has violated any noise ordinance. There hasn't been a single dB reading that has been taken or any citations issued. We were assured by City Council that this would not even be brought before the Board of Adjustments without multiple dB readings that were above acceptable levels. Been awfully quiet everywhere with the COVID lockdown. Going from no traffic on the streets or businesses open has to be quite an adjustment for the residents, but businesses need to get back to normal. We ran our business for 12 years without any issue. I have a hard time believing that our crowds were always for 12 years so much quieter than the current crowds. Seems that the city is unwilling to set the expectations with the area residents. This is not a purely residential district. Not liking a business is not a valid excuse to remove it. Residents need to be aware that businesses are allowed to operate legally instead of encouraging them to make continuous complaints. In closing, it seems that the CUP has become a catch-all excuse so that when people don't like a business, they're potentially able to close them down as a nuisance. You put conditions in the CUP, but it seems like any condition can be used under the guise of a nuisance. The business should be able to have time to prove itself without being harassed for just operating. Thank you. That's all I have.
Thank you, Nancy. This again is Attorney Matthew Gilbert representing Mr. Larry Mason Jr. And I just want to set a few facts in motion, as well as we are definitely on record going to object to the staff's report that was presented. There is just too much potential bias within both. As we listen to the recordings, the videos, they mostly don't relate to my client's business and have not thus. And so we really feel that, if we look at how the city and how the zoning is really being used in this instance, we just really feel that looking under the general use sections of section 134, -18.2. It talks about other city regulations. It says specifically that provisions of the zoning ordinance that are inconsistent or in conflict with other provisions found or adopted in other ordinance or regulations of the city, then the more restrictive provision should govern unless expressly stated otherwise. In addition to that, 1.83 mentions that the city is not responsible for monitoring or enforcing agreements or covenants among private parties. And so we feel that at this point, just the bias policy that was noted, specifically number 9, condition number 9 under the CUP docket zone 2010-00137, which actually approved the conditional use permit back in 2010 at a vote of 5-0 by the board. Condition number 9 just offers just too much opportunity for bias from the zoning enforcement officer. It reads that the conditional use permit shall be subject to amendment or revocation in the zoning enforcement if the zoning enforcement officer determines that the operation of the business becomes a nuisance or exhibits a pattern of violating the conditions set forth in the conditional use permit. At this point, we have unsubstantiated complaints that have been presented to the board without any real sound evidence to really make such a critical decision immediately. So for those reasons, we would like to deny the recommendation from the staff member to go ahead and immediately revoke this conditional use permit. And as we start to speak to bias, I think it's really important that you hear from the business owner, Mr. Larry Mason himself. Larry, can you go ahead and just share your experience so far?
Okay, sir. You're coming up on your time limitation here. So unless this is very quick, he'll have to comment in support of your position.
He'll comment in opposition.
All right. He can have up to 5 minutes at that time then.
Perfect.
That sound okay?
We'll save there. That sounds great.
Thank you.
Okay, board, I really appreciate. Hello, board. I really appreciate you letting me speak. I just got a couple of things I want to touch on, and I'll make it really quick. I just want to know. It took me a little time to prepare for this meeting, obviously, because we just received our information on 9/22/2020 of all the evidence that was presented, and all of the evidence that was presented to you guys actually wasn't presented to us. Obviously, you know, my business is not La Hacienda. So I don't know what that video with La Hacienda even came from. So I'm in strictly denial. I oppose that video and all the evidence that was shown. And in our previous meeting, Mr. Joe Gatto told us that he would do readings of the jukebox upstairs before we would be recommended to be on the board, to go against the board, or go to the board of adjustments. I'm sorry. And there has been no readings of any jukebox or any jukebox on our rooftop, and we're here at the Board of Adjustments. I thought that was unfair and a prejudice towards the business that I'm trying to run during this pandemic. Also, I'm gonna leave you with this because I'm not gonna go over everything. I don't want to, use up too much of you guys' time. But I met with Mr. Al Tunks, which is assistant captain of Des Moines Police Department yesterday, and we had a conversation. And I wanted to know, like, okay, what am I doing wrong? And he told me that, well, I have no idea what's been going on down there. And I said, okay, you might not. And he goes, well, I know that I signed for off-duty police officers to be able to work at your police, at your establishment. And haven't you been having off-duty police officers? I said, no, Mr. Tunks, I haven't. I said, I filled out the paperwork to get it done, and I still haven't seen any police officers. He's like, that's weird. So I know for a fact that I have reached out to the Des Moines police officers to have police officers out of my establishment to make sure that there's no incidents that go on, let alone I haven't had any incidents happen at my establishment to show any type of resistance to the neighborhood association or anything going on in the neighborhood. Also, I want to leave you with this. I have went over and beyond the accommodations of the first meeting that we had with the city to, you know, a lot of the stuff I was already doing, but I went over and beyond. I had more security come in the building. I go out after we close and pick up all the litter on the sidewalks. I make sure there's nothing across the street. We go outside and make sure everybody leaves in an orderly fashion. And at 1:45, the bars actually close at 2:00, but we get them out of here sooner so I can make sure the streets are cleared, because I know it is a residential area also, that residents live across the street. Thank you for your time, and that's the end of what I have.
All right. Hey, Larry, would you be willing to take some questions from the board?
Of course I would.
All right. Board members, do you have any questions for the operator here, Mr. Mason? Larry, I've just got a couple notes here myself, so I'll go ahead and throw you a question here. So,
okay.
When did you take over operations at this establishment?
My lease date that I signed was February 19th, 2020. Obviously, with the pandemic, we weren't able to open up until June 2nd of 2020.
All right. So basically, you opened in June, and what's the trade name of your tavern there? What's the name?
It's Club 525.
All right. Is Club 525 on a sign on the building? Is it readily visible what your business name is under your ownership?
Sir. We got a sign. We have a sign inside the building that's hanging in the windows. We haven't been able to be up and established long enough to afford a sign to put outside the building yet.
All right. Okay. Which is fine. No problem with that. And of course, if you're going to put a sign up, check with the city.
I most definitely will, sir.
Yeah. But is there any remaining signage that was related to one of the past tenants, like La Hacienda as an example?
No, sir. I took them all down, and the sign that was on the front of the building that I believe you guys approved, I even took all the signage off of that, the lettering.
Okay. All right. I got you there. So, so Larry, if you signed the lease, I'm assuming you signed that in February with Nancy Wilson, correct?
Yes, sir.
All right. So at that time, when you sign a lease, I'm assuming it's somewhat of a contract. It says what you'll pay per month and how long you can have the lease. Did Nancy provide you a copy of the conditional use permit and therein the conditions for the operation?
Yes, sir. I have the conditional use permit. I've read it thoroughly. And I also, on the jukebox upstairs, I have the decimals, the packet of the decimal enforcement that you guys, I'm not sure. I'm sorry. I don't know the true name of it, but I have a packet of the decimal force next to the jukebox upstairs. And also our jukebox is set by the guy that does our jukebox. It's set for the decimals not to be over what it's supposed to be set at.
Yeah, I got you. Well, so and one of the reasons I ask is you're kind of on my wavelength here. Mm-hmm. One of the key conditions that the Board of Adjustment put on in being supportive, as I think Nancy said back in 2010, it was 5-0. We're like, give it a good shot. I was the vice chair of the board at that time, and I remember this. And we wanted to allow a tavern to be there, but we specifically, and this is all on the record for anybody to go back and find, we specifically spent time to make it clear that the patio operation had to be extremely limited so we didn't have noise emanating from the patio, because this is the reverse. It's not that people should understand there's bars down there and get along with it. We understood that there were people living there and would be other people living there. So that's why we specifically had number 5 in there. Any outdoor sound or music shall be limited to levels that would be considered background. To me, that is like Muzak. You have a little tiny JVC speaker, 6 inches. It's stapled to a post. It's pointed internally. That's what's in my head for that. Okay. So I don't know that you've been jamming on the jukebox or having live bands or any amplified sound, but any one of those would be in violation of those conditions that are over a decade old, the owner knows, and any tenant was provided with, as you've stated.
Yep, and I totally understand that usage permit, and we actually, like I said, we got our info. I hope I didn't interrupt you.
No, that's fine.
Okay,
that's fine.
Yeah, we actually got the evidence that was presented to us of what this meeting was going to be at yesterday. So we didn't have time to upload videos. We didn't have time to, do any of the stuff. I was sorry that I kind of stuttered around and things, because I tried to get as much information as I can, but being straight to the point because I know I only had 5 minutes.
Right.
Last night through to today. This morning I've been working on it too.
Yeah.
So, I wasn't able. We have a video though, and standing in front of my front door on the sidewalk, you cannot hear the music from upstairs.
Right.
So the music on those videos, the music on them videos that she presented are the motorcycles. And we've had this discussion, and I've talked to them about it. And I even go as far as going outside and telling the motorcycle guys, and they actually do it for me now. I tell them, don't turn your music up, don't rev your bikes.
Right, right.
So, I mean, I'm policing the outside area of my establishment also, not just when we close, whenever I see the motorcycles pull up and everything.
Yeah, yeah. So Larry, we have some other testimony to take, and I just want to ask you a question or two there, but to kind of set the stage here of where our decision-making has to be, the board is hearing this item because it's been brought to us by the zoning enforcement officer. And basically the staff is saying they're recommending that the conditional use permit be revoked. So then therefore there can be no tavern there. Now I'm assuming that's not what you want.
Of course not.
Would you be, you've got to give us then an alternative. Do we just walk away and say, well, all of these concerns are obviously foolish? Or would you be willing to sit down and work with residents, the police department, the neighborhood, and put together one of those good neighbor agreements?
I've reached out to the police department. The neighbors come over and buy food because obviously, I'm just not, I mean, I have food here also in the restaurant part of it. They come over and buy food. So I've talked to them and everything. But my whole thing, my thing is I really haven't done anything wrong. So it would be nice to at least let me establish a business and try to see if I'm going to do something wrong before, I'm handcuffed with, being able to actually run a business. The pandemic has, annihilated my business. We don't have very many people, obviously those pictures I wish I did have that many people inside my establishment. I mean, it's just, I just would like to give a fair chance to be able to run my business.
Okay. All right. Fair enough. All right. Well, we will check back with you because you guys have the last rebuttal here. So you or your attorney will have up to 3 minutes here toward the end. So
thank you, sir.
You bet. Okay. We were just a shade out of order, but I don't have a problem with that. Are there any other speakers in opposition to the city's referred enforcement action? Is there anybody who is in opposition to what the city is proposing on revocation of the CUP? Anybody else want to speak?
Yes. Good. Can you all hear me?
Yes, we can. Here?
Hi, this is Cameron Middlebrooks, resident, 1511 12th Street, Des Moines, Iowa, 50314. Also serve as the branch president of the NAACP here in Des Moines as well. And I did want to speak into opposition of item number 5. I strongly would like to deny the staff recommendation to revoke the conditional use permit for many of the reasons that Mr. Mason, Nancy, and his attorney and the attorney have stated before. Particularly when it comes to the evidence, being that they were not given an opportunity to review this evidence in a timely fashion in order to have an even more strategic pushback to that evidence. I believe that's egregious in itself. This was information that I believe they requested after the initial meeting last month. They were stated that they would receive that in a timely fashion. I don't believe a 24-hour notice is a timely fashion. In addition to that, as he stated, many of those pictures and video come from a time before Mr. Mason was actually in operation at that building. In addition to that, I do believe from NAACP standpoint, and also just so full clarity, I do work for Iowa State University as a minority business coordinator. So I've worked with Larry in the past, worked with many minority-owned businesses in and around the Des Moines area. And I understand, I think we need to also focus on the barriers that they have to success outside of just going through the city. Minority businesses have struggled in this city for quite some time. And Mr. Mason has taken an extraordinary step to open a business in the middle of COVID. This is an establishment I have frequented many times. And I have seen Mr. Mason utilize every COVID standard necessary to operate that business as safe as possible. I've also been in conversation with him about the many times that as he has addressed, he's gone out and policed the streets just as he's policed inside of his own establishment. I think it's also important to note that even before that conversation that he had with Mr. Tunks yesterday, Mr. Mason's did have an approval about a month or so ago and is yet to receive any help or support from off-duty officers. He has instead gone into his own pocket and added extra security to ensure the safety and the noise ordinances were under control. I believe they should be afforded a much broader opportunity to be in line, not only with their neighbors, but also with the city. It is my opinion as of right now, based on the recommendations or based on the actions that Mr. Mason has taken throughout the summer, he has stayed in compliance with this order. In addition to that, I believe this is kind of want to go back as well. So some of you may know I also serve as a chair of the Civil and Human Rights Commission. A few months ago, we put forth a anti-policing ordinance. Attached to that ordinance was a resolution to start a committee entitled the Policy, Practice, and Review Committee. This committee is not only tasked with reviewing policy and practices from the police department, but also enforcement arms of the city. The reason being that we've seen unbiased practices and unbiased policies that have put minorities in a disadvantaged situation. As far as I know, Larry is the only Black-owned business in that district and maybe the only Black-owned restaurant and or bar in the downtown area. As Nancy has said, she has been in there the previous 12 years, has never had a complaint. Many of the other businesses and restaurants and bars, I'm pretty sure have had fewer complaints. But Mr. Mason has only had complaints and not actual violations. And for this board to take up and remove his ability to operate as a bar and restaurant will severely impact not only him and his business, but also the number of employees that he has, many of which are also minorities working there. In the city of Des Moines, per the One Economy report that came out in 2018, the unemployment rate for the city was 6.5, but the unemployment rate for African Americans was double that. Now, I do realize since then that number has gone down, but the ratio and the disparities are still the same. They've also been exacerbated through the months that we've been dealing with COVID-19. But Mr. Mason has continued to employ many of our residents. He has done so in a safe way. He has done so in a compliant way. And again, I truly recommend that this board goes against the staff recommendation and allows this business owner to operate in a well-mannered space and also operate in a space that they can come to an agreement with the neighbors and the police department to help support him in policing the outside of his establishment, which is hard to do when you're running a business yourself inside. Again, thank you all for your time and appreciate the opportunity to speak on his behalf.
Appreciate your comments. Thank you, sir. Okay, is there anybody else who wishes to speak in opposition to the city's enforcement action?
We do have two people on the phone numbers. I'll let the number 515-210-6422 go first, but they'll need to state their name.
Hi, this is Carrie Nelson. Can you
Yes,
hear me? Hi, this is Carrie Nelson. I'd also like to oppose. I'm going to be brief with my comments. However, I've been down to Larry's establishment several times, in fact, trying to promote local artists who also are struggling. In this time, I worked for many years at Meredith Corporation. And not only is Larry's bar unique, they're trying to bring in that art vibe into the East Village. So it's not just a bar. And the times I've been in there, I've never once had any of those violations, nuisances, or what have you. So I would like to vote against the city's recommendation.
Okay. All right.
Carrie, can I get the spelling of your first name and your address, please?
It's Carrie, Karrie, Nelson, Nelson. And 12421 Meredith Drive, Urbandale, Iowa, 50261.
Thank you. All right, the next speaker we have is at number area code 773-621-0030. And they'll have to hit *6 to unmute themselves and then give their name and address, please.
Good afternoon, everyone. This is Reverend Rob Johnson. Can you hear me?
Yes, we can. What's your address?
Awesome. So use my business address of 3300 Southwest 9th Street, Des Moines, Iowa.
All right.
So I too want to speak in opposition of this because I want to give you just a few stats here. In June 30th of 2020, there was a report that came out that talked about small business trends. It told us that 80% of small business owners have been hurt and have taken a significant financial loss during the pandemic. As a matter of fact, it tells us that 55% of those businesses will never recover, which then puts communities such as African American communities and Latino communities at a disadvantage when it comes to small businesses. I would like to reiterate the fact that Mr. Larry Mason Jr. opened a small business in Des Moines, Iowa, in the middle of a pandemic, understanding that he was trying to provide an opportunity for people in that community, but also a small business for the state of Iowa. And to add to that, he has taken money out of his own pocket in order to ensure that the safety of his establishment, the neighborhood, and the residents are taken care of. I believe Mr. Mason has gone over and beyond his call of duty to make sure that he is in compliance. He is making sure that he is doing it by the book and making sure that his business is an upstanding business for those of us who frequently visit. I myself, I may not drink alcohol, but the food there is fantastic. So I want to absolutely object, and I completely agree with Mr. Cameron Middlebrooks and the lady who just spoke that the city should deny this, that this board should deny that request. And I would even go as far as to say, let's deny this request altogether and give this small business a chance in the middle of a pandemic to be successful. Why put more hurdles on a business when there's already one that none of us can see, which is called COVID-19? Allow this business to flourish, give this business a chance, and we thank you for your time.
All right. Thank you, sir. Anybody else that wishes to speak in opposition to the city's requested enforcement action?
Do I still have a mic on?
Yes.
Yeah, this is Cameron Middlebrooks. If I could have the opportunity just to say one more thing on Larry's behalf.
Well, sir, no, you've already spoke once, and the applicant gets the business operator will get 3 minutes for rebuttal for closing statements.
All right, thank you, sir.
You requested to see that the CUP that stated that nearby residents should expect the level of impact created by businesses. I have that.
Okay. So these were the conditions that were issued in 2010 for operating conditional use permit to sell wine, liquor, or beer. And this related to expanding an existing tavern to add on the rooftop.
Yeah.
Yeah.
Can we correct that record? This is Matthew. These are the findings that were made by the review committee or board, whoever reviewed the conditional use permit. The actual conditions are set out 1 through 9 on the back page. There you go.
Yeah. Yeah. As a point of order, he is correct on that. I don't want to debate merits here. Each side gets a chance to give its testimony, but yes, those are the 9 conditions that the Zoning Board of Adjustment attached to allow that conditional use permit to expand that existing tavern to add that rooftop patio. So regardless of who the operator is, those are the 9 conditions that have been consistent. And those are the 9 conditions that the property owner should be more than aware of as well. Okay, so we're we're going to keep the hearing in the order here it's supposed to be. Do we have any other folks that wish to speak in opposition of the city's enforcement act? Those that have not already been recognized to speak. Okay, so we're going to back up a bit here now. Are there any speakers in support of the city's enforcement action request? So this would be non-city staff. It would be anyone else. Anybody speak in support of the city's requested enforcement act? Bert, do we have any hands raised or any?
I am not seeing any.
Okay.
The only, yeah.
Okay. Then we'll move on. Just for the record, are there any speakers who wish to speak neutrally in regard to the enforcement action who have not already spoken? Okay.
We do have one caller on the line with the number 515-707-9221. If they wish to speak, they need to hit *9 on their phone.
Yeah. Yeah. Yeah, for that person who's been listening, if you don't want to speak, that's fine. If you want to speak, hit *9 so staff can see that you want to speak, and then they will unmute you. And if that person hasn't spoken yet, depending on, if they want to speak in support, opposition, or neutral, so be it.
Right. This would be their last opportunity right now to speak.
Okay. It may be just someone who wants to listen to the hearing. Going once, going twice. Okay. All right. So Bert, then moving on, do we have questions for the zoning enforcement officer or other city staff from the board members?
Mr. Chair, this is Lynn Carlson. I have one for Sue Ann Donovan.
Sure.
Was that did Joe Gatto communicate to you after the meeting where he promised there would be 3 readings and before action was brought to these people? And does he have the authority to do so?
The discussion, this is Sue Donovan, zoning enforcement officer. The discussion at that point was noise violations, which would be a decibel reading for failure to have, or for having sound too loud on the patio. There was a discussion about if it came back for sound violation, we would do 3 readings. What is really before us now is the general nuisance question and how to resolve that.
Okay, thank you. And these recording dates, do you know, were they dated at all? This La Hacienda and the motorcycles, were those dated?
I don't recall a date, but I know she sent them in and recorded them after the change of operation when she was communicating with me. I can't speak for her, but I would guess that she had La Hacienda on there because that was the last name of the business.
Right. Okay, thank you.
Okay.
Mr. Chair, I have a question.
Go ahead, Justin.
Yes, and maybe this is not for Sue Ann, but I'm trying to figure out the notice issue. It sounds like from the appellant that notice wasn't really provided in a timely fashion. Can you comment on that, or when was notice provided? When was notice sent out?
Chair, members of the board, I don't believe that they're talking about notice. They get notice of the hearing under the rules of the board. Staff generally presents our case at the hearing. We did provide them. I usually try to hand out what we're going to present at the board before the meeting. I usually do that in person in paper copies. Under the COVID and the way we're doing meetings now, we did send them the information on what we were going to present to them yesterday. It was, that is our normal practice. That is the way the board's orders and the ordinance work.
All right. Other questions for Sue Ann or staff? Sue Ann, I've got a question here. It sounds like, from Larry's testimony, he's trying to run an honest business, really didn't even open until June. But this is not the first time that we've had reports of a nuisance issue, whether those are founded or not, at this location. And it's not the first time that this had been brought back to the board since we issued the original conditional use permit. If I'm correct, and that's my question to you, did the board not hear concerns with this location within the last year or two in regard to outdoor loud music, amplified sound, etc.?
We did. It was brought back to you in October of 2019. At that time, the operator, which is not this operator, and what happened then doesn't have anything to do with what we're doing today.
Correct.
That operator was actually running amplified music through outdoor speakers.
Okay.
And when we got complaints about loud music, we realized that they were running the music through the speakers, which wasn't allowed. They agreed to quit doing that on the upper patio. And so you did not revoke. You found that they should just adhere to the noise control part of the decision and order.
Yeah. Okay.
And
all right.
I think, to be honest, Larry or whoever's running this patio bar is probably, as the board envisioned when they first issued the approval, is going to have problems with the noise coming off that patio directly across the street into apartment units.
Right.
I believe the best use for that patio is probably for people to be sitting and gathering with just background music, not necessarily a jukebox, not necessarily anything that produces loud sound, because then it isn't going to travel across the street and cause a problem for the residents. I do understand how sound travels, and you could have a band or some sort of amplified music on the upper patio and probably not hear it on the sidewalk, but hear it directly across as if you were sitting on that patio. So that is a problem, not necessarily of Larry's own making, and it is unique to that patio being up above, but that is what causes some problems for the neighborhood.
Right. I certainly understand that, and I do want to put this in perspective, but I think there's something to be said that for a decade, the intent of the Board of Adjustment in wanting to allow a use of this property, but ensuring that it fits into the character of the community to balance all needs, that intent has remained clear throughout. So how we move forward, we have part of this agenda item left, is to be determined, but I just that was the reason I had that question, that some of these issues have come up before, not related to this operator, but this location, this conditional use permit, and the current owner of the property. Sue Ann, this picture you've got in front of us, is there a specific date or description what's going on here?
This was the last complaint that I received, and it was regarding a party that was on the upper patio and maybe inside of the lower level. The complaint was about the loud sound from the patio. His other complaint was it's overcrowded, there's no mask, it doesn't meet the guidelines for COVID.
And none of that has purview of the Board of Adjustment, correct?
No, it doesn't, but it was in the complainant's mind was another example of creating a nuisance with the number of people up there and the noise that was coming off of the patio.
Sure. Yeah, you know, if people are laughing and talking, I really don't think the Board of Adjustment has much authority in that regard. But when I look at this picture, it would indicate to me that everybody's looking in the same general direction. So odds are there's some live outdoor music. If there is live outdoor music, it better be non-amplified. And if they're just looking at a jukebox, then that jukebox would also need to be at an auditory level that is background in nature. It would appear there's maybe a little bit more going on there. So if we need to get down to brass tacks on this, we're going to have to figure out how to deal with that. But this is about questions for you at this time. So Do my colleagues on the Board of Adjustment have any other questions for Sue Ann or staff?
Mr. Chair, I do. This is Justin Gross, and this is more of a, I guess, for legal, and I don't know the answer. It's why I'm asking is, does the board have authority to recommend a continuance to allow the appellant time to review more of the exhibits and evidence that's being submitted today? It would also allow time for them to talk to their neighbors, city staff, and police, and hopefully resolving the issue. Is that something that this board has authority to do?
And that may be a question for Judy.
Yes, and I was just going to answer that. Thanks. I believe it is within your authority. You can entertain a motion to allow additional evidence. I know I've heard that in other types of cases that have come before you where a question has arisen and you actually needed to have some more information that was available, but nobody anticipated it. And that is, in essence, the framework we're in right now. We have heard new information from both sides, and I don't know that it would be an impossibility for you to make that motion and allow the parties time to try and get the additional information for you, and then perhaps work out whatever additional steps as well.
Yeah.
Thank you.
Okay. All right. Any other questions for Sue Ann or city staff? All right. If none, Bert, could you do me a favor and bring up our order of appearance on this one? Because again, it's a little different than normal. Okay. Sue Ann, you have an opportunity for a closing statement or any other rebuttal. I believe that should be around 3 minutes max. Do you want to do that? Or
yeah, I will do a brief, Chair, members of the board, just a brief statement. I totally respect all of the information that's been brought up by the owner and the people that have supported the owner. What's before us is not necessarily equity or other ordinances or the small business, although I do understand those comments. But what's really before us is how do we make this business work at this location so that it can coexist in a mixed-use neighborhood that has residents. East Village has prided itself on being not Court Avenue and being a more sort of quieter area of the city where, and I'm sure this is a nice club that people can sit and have a conversation. And that's sort of what East Village is sort of looking for and wants to be. So I think we have tried to work it out. We're still getting complaints. I would rather not see complaints. I don't like bringing these things forward. If a continuance will help us get to a presentation back to the board that comes up with a way that we can help this business grow, help it prosper, help it stay here, I'm all about it. That would be a great resolution. If not, then I think we have to look at sort of the worst case scenario, which is not my first choice or second choice. So,
right. Okay. All right. Thank you very much, Sue Ann. Okay, so Larry, either you or your attorney or all in concert, in total, you get up to 3 minutes here. So
thank you.
Make some closing remarks.
Yeah, thank you, Bert. This is Matthew Gilbert again here representing Mr. Larry Mason and his business affairs and interests. And I'd just like to start with, letting you understand Mr. Mason is a good guy. He's a mentor to children. He's involved in youth sports and athletics. He is really engaged in wanting to sort of move the community forward. And this opportunity that landed in East Village was primarily for him to build an inclusive environment. And ever since he's been there, he's been fighting uphill battle with city officials, with staff to do such a thing. And so what we are really recommending, because, at this point, The zoning enforcement officer is doing her job to a T, right, to a strict standard. However, I think that strict standard also doesn't carve out space for bias, right? And specifically, if we look at the decision in order and the conditions that were noted under the original CUP dated August 25th, 2010, we'll notice that the zoning enforcement officer has a level of discretion that is just too opportunistic to be tainted with bias, right? And so, as I mentioned to you, when we talk about conflicting provisions in the city regulations, one of those provisions right now is the City of Des Moines unbiased policing notice. In that ordinance, the first line of that ordinance reads, "Unbiased policing. The City of Des Moines shall be committed to the unbiased, equitable treatment of all." So unlike what the zoning enforcement officer mentioned, that this is not about equity, no, actually, this is exactly about equity. And I think because of that reason, and because the board acknowledges that there's really not a comfortable competency from the board to sort of maneuver and sort of know how to enforce this particular CUP, I do think that the primary recommendation, because we've identified a bias policy, we've identified bias enforcement of that policy, and if we want to get to a uniform standard, then we have to get to the same high burden standard that Mr. Mason is being held to. And that high burden standard would be the unbiased policing ordinance under Chapter 86. What that would allow us to do is to really look at the potential gaps that are present, that are now becoming human errors, or now becoming neighborhood errors, when we could really resolve this with equitable policy. So for those reasons, I would acknowledge that we really look to make a recommendation that the board have this be reviewed by the City of Des Moines Policy and Practices Committee. We noted a few things in the evidence. First, there was a photo. Folks in that photo, looks like, if it is even applicable, right, to my client, looks like they're taking a picture, right? You see people all staring at the same place. They're not listening to a band. In addition to that, the auditory, the noise issue is just coming from a level of comfortability and complaint that I'm not sure that the neighbors have really reckoned with the decade since this ordinance since this conditional use permit has been approved. So I do think that there is a chance for some real cool community engagement and community and relationship building here. But I believe that it starts with the city staff, and I think it starts with the zoning enforcement officer. And at this point, we've only talked to Sue Ann twice. And the second time we talked to her was to be notified that we would be heading to this hearing. Under your statutes, under your rules, there's a 30-day requirement that at least 30 days be provided to before a hearing. We are kind of well within that, and I'm not sure why that is, but this seems a little bit rushed. It also seems a little bit biased, and for those reasons, I just feel like there's nothing that has been presented today that can make a healthy decision for revoking the conditional use permit. So for those reasons, I would ask that the board please deny the immediate revocation of the permit and look to recommend on record that this be an issue that be reviewed, not a private matter, a policy matter, a systemic matter, be reviewed by those that are more competent, and that would be the Policies and Practices Committee. Thank you for that.
You bet. All right. Thank you, Matthew. Okay. At this time, we're going to close the public portion. So we're through with testimony and comments. We're going to close the public portion and go to board deliberation so that the members of the board will talk here and everybody, of course, can listen. Colleagues, any thoughts, ideas, concerns, or suggestions here?
With this owner being fairly new and having the pandemic, I kind of wonder, people are bringing the complaints forward because they've had it and they're home more often. I would like to see us to give them some way to, I don't know if we need to go as far as the good neighborhood agreement, but to work out something, giving him a chance, setting some parameters, like how often maybe some decibel readings are done. And I don't know who would be in charge of that or how it would be recorded, but those are my thoughts right now to start with.
Okay. All right. Others?
Hey, Mel.
Pierre raised his hand.
Yeah. Hey, Mel, this is Dave.
Hey, David.
Good afternoon. Hey, I'm kind of confused with this whole thing. I think some of the evidence presented, I'm not sure that we even know when it occurred.
Yeah.
Whether the picture that we saw, where they're getting their picture taken, they're looking at a band. You know, the La Hacienda, we've got a gal who obviously lives across the street, had a cell phone, recorded some stuff. You know, I think in fairness to this owner and in fairness to the city, because I don't think we've done our due diligence on this thing very well, based on the evidence presented today, and he's tried to hire off-duty police officers, which they haven't been evidently on site yet, which I think could help. If anything, it can help substantiate some of the stuff. So, you know, I think we need to work towards some kind of a motion here that we're going to allow this owner to work through this. The city needs to work with them, and we need to find a way to help this guy be successful. And if he can't be successful because of the location and because of the nature of the business, and it continues to be a hindrance, at least let's say we've given it a chance and we've done the best thing we can for everybody. Yep. You know, and I think too, and some evidence was presented about, you know, if you live down in this district, you're going to expect to hear some noise. That doesn't mean that you have to, it has to be a concert every night, but to hear motorcycles pulling away from a business, what control does he have of that guy? I don't think he has zero, other than you can say, hey guys, can you please be respectful of my neighbors and not have your radios up so loud, and you don't need to rev your engines when you're leaving at 1:45 in the morning.
Right. Yeah.
So I think we need to work towards some sort of a motion that's going to allow him to function. Some of this stuff's been dropped in his lap, it sounds like, within the last 72 hours, which that's not fair at all. And I don't know that we as the city have done a very good job of substantiating some of the stuff that we brought to them. Mm-hmm. So those are just my thoughts. I'm open to anybody that wants to make a motion, but I'm gonna vote for giving this guy a chance to get straightened out, because I think he deserves it.
Yeah.
And this is Marlis. Could we possibly get legal's assistance on what that motion would be like?
I don't necessarily know that we want legal to suggest one, but they could comment if we want to suggest something. Could we look at deferring the review of this conditional use permit for 30 days and looking at, as may be needed, amending the conditional use permit to either clarify or add to conditions that will allow the operation to, continue while ensuring reasonable protection of the intended neighborhood character? We do something like that. So, Judy. Somehow I'm missing some sound, unless that's just me.
Chair, members of the board.
Yeah.
This is Sue Ann Donovan. To try and maybe figure out a way through this, I don't even think they're fully open. I think bars can open in Polk County now.
Right.
Is there a way to say that for the next 90 days that we continue this and try to work with the owner over the next 90 days to come up with some operating standards that DMPD and zoning can work with to make this successful? For instance, maybe no jukebox up there and reduce the sound on the patio and keep the music down on the lower level.
Well, if we continue this for 90 days, let's say, whether it's 30, 60, or 90, if you want any interim conditions, I don't know if you're asking the board to do those or if we just step out of the issue for 90 days as a jury, and then you come back in 90 days, and if it's about an amended conditional use permit, or if Sue Ann says, I don't want to bring this back, we can always do that. But I don't know if you want some homework here this afternoon on what those operating conditions need to be or not.
I would leave that to the board. I was, I guess, looking for 90 days for us to sit down and talk with the owner and their attorney again, DMPD, and try and figure out where the pressure points are that maybe we could work through this.
Sure. And what I'm going to do here, I want to listen to my other colleagues, but since it was kind of a question while we're in deliberation and Sue Ann spoke, I am going to give both. I'll give Larry or his representative an opportunity to see what they might think before we decide to vote on something.
And
so I want to go back.
Chair, this is your legal counsel as well. I'm sorry, I was muted. I didn't realize that. I would also concur with the idea of continuing it for a period of time. I don't know that there are interim conditions that you can impose at this point, just given the state of the uncertainty of what those might be. That would probably be best left to the parties to try and work out, and then come back at that point if those have been solidified and seek amendments to the conditions.
Great. And if we choose to do that, Judy, the current conditions then would still apply as kind of a baseline golden rule. Everybody might want to review those as you operate your fine establishment, and then sit down with staff. Okay, so let's continue the discussion with my colleagues here. Since we might have...
members of Chair, did you want to give the other side a chance to respond since I spoke?
I will, and I just mentioned that, but I also want to hear if my colleagues might have any other thoughts or suggestions that could then have some implications for the other side of the coin here.
Thank you.
This is Lynn Carlson. I really like what Dave said about we really haven't given him a chance with pandemic conditions and everything. I am all in favor of giving 90 days and not putting any conditions on it. He's heard enough that I think he knows. You can talk to Sue Ann. I might try approaching the neighbors across the street, maybe the ones with the second floor windows, and reach out to them and see what their complaints are, and just let it open to him. It sounds like he's got a lot of support, and to see if it's still an issue in 90 days, if it needs to be brought back or not. But Justin already asked if we could delay this or continue it. And those are my thoughts. I think that's a really good idea in this situation.
Mm-hmm. Okay. All right. Other thoughts? Okay. So what I think I'm going to do here for a minute, Larry, do you or your attorney want to? I'll give you a couple minutes here. You've kind of heard maybe what's being thrown out here. I'm not saying you have to agree to it, but I'd like to hear what you think of it.
Thanks. I really appreciate that. I will definitely give Larry a quick second to, acknowledge his assent, but I'd like to reserve that for a time where him and I can talk. So I'm not sure if he'll be able to respond with the assent that you're looking for, but I will say that I think we're moving in the right direction. I do think that, having a continuance for a period of time without any new conditions, I think is right. I think what that would allow for us to do is to really explore, what are those gaps that, Sue Ann may be running into, where she's sort of put in a position to sort of be more enforcer versus be more sort of community builder. And I think that, the neighbors in that area have a great relationship with her. Unfortunately, my client hasn't had an opportunity to really develop a good relationship with her, whereas a lot of these complaints could really be resolved with a phone call. But instead, it gets tracked, it gets piled on your record, and then now we're here. So what I would suggest is that we continue to look at a continuance. But in that time, I would say that we do make a formal recommendation that this that this particular policy, right, this particular practice be reviewed by the Policies and Practices Committee. I think that there are just so many opportunities to include bias in how the conditions are written. So until we actually have an independent body that could really sort of look at that, I definitely think that is just sort of out of our wheelhouse to try to make up something. So I would like the idea of us sort of being able to present either an amended conditions or just some clarifications to these. But as you mentioned, my client definitely understands what's going on. Unfortunately, he's had to understand what's going on under the gun. And not only that, he's got a business that's starving right now, and this is not helping his business. So definitely would appreciate some grace, and definitely would appreciate the cooperation from the board to really see that the Policies and Practices Committee actually look at being involved in this process, and then not just be my client versus the neighbors, because that could get real ugly too. Thank you.
Yep.
Oh, we don't want that.
And Matthew, if we're inclined to defer this for 90 days or continue it for 90 days, you do understand that it would probably be a good idea for everybody, I'm talking about the operator, to sit down and re-review those conditions within the permit, and certainly try to evaluate and understand those on their own as best possible. So,
we assent to that.
Music shall be limited to non-amplified performances.
Mm-hmm.
So
we haven't had any to date. We don't expect any. Again, most of the things that we're talking about as far as complaints have nothing to do with the rooftop. They're outside. They're in the streets. So with that being said, we don't know. We can't ID every single person that's in the East Village. And just because they're black and brown does not mean that they're a patron of my client's establishment.
Well, and I would not assume that anybody is or isn't a patron of any establishment based on their race, color, creed, religion, financial background, for-profit or non-profit. I can only speak on behalf of myself and my observations, but in the last 14 years I've been on this board, myself and my colleagues have been consistent in granting everybody the same fair shake and ask for the same fair expectations in return. So that's kind of my job to ensure that.
We would appreciate that same consideration in the staff report, especially when it comes time to review critical matters in critical periods of time. Thanks, Bert.
All right, thank you.
Mr. Chair and members of this board, Justin Gross here. I'd like to make a formal motion to table the reconsideration of the conditional use for this property for 90 days.
Would that be to December 16 or to January 27?
I would say January 27th in the motion.
Okay.
Using the current conditions.
So basically 3 months from now takes us to January already, doesn't it? No? Doesn't it just take us till December?
Yeah, but it's December 16, so it's more like 75 days. All
right, fine. Yep.
We still have COVID conditions off and on.
Yeah. Yeah. So a minimum of 90 till the next hearing when a minimum of 90 days has passed, which would be January. Great. Okay, so we got a motion from Justin.
I'll second, Mr. Chair.
Okay. My loudest second was Cindy's. So we've got a motion from Justin, a second from Cindy to continue this item for 90 days. The board may not have to rehear the item, but that's the motion on the table. So we'll take a roll call vote.
Marlis Jones.
Aye.
Cindy Smith.
Aye.
Nathan Blake.
Aye.
Lynn Carlson.
Aye.
Dave Gare.
Aye.
Justin Gross.
Aye.
And Mel Pins.
Aye.
Motion carries 7-0.
Okay, so I encourage everybody to start working together between staff and the operator, and I think the property owner should make sure that they've got their head in the game as well. At the end of the day, the property owner profits from owning that property, and I personally believe that that they should be paying attention what's going on there. And if they've got a good tenant now, then we can keep it. Okay, so that concludes our formal hearing items for today. Minor business to still deal with would be approval of minutes from our August 26th meeting. Everybody's had an opportunity to review those. If there are any corrections, please let us know. If there are none, anybody who was present at that last meeting can make a motion and then vote on approving the minute.
This is Nathan Blake. I'll move to approve the minutes of last month.
I'll second. This is Cindy.
All right. Motion by Nathan, second by Cindy. We'll take a roll call of all those that were present. Say aye if you were present.
Nathan Blake,
Aye.
Lynn Carlson,
I was absent.
Okay.
Dave Gare,
I was absent as well.
Justin Gross,
Aye.
Marlis Jones,
Aye.
Cindy Smith,
Aye.
and Mel Pins.
Aye.
Motion carries 5-0-2.
Okay. All right. And Bert, do we have any other business we need to tend to?
Yeah, I just have a couple quick things. Our October and November meetings are going to be held over Zoom again for sure. You guys have all been doing a great job. So I appreciate all of your efforts and whatnot. Right now, we're tentatively set to be back in person in December, but to be honest, I wouldn't be surprised if it did get extended once more. But just know that the October and November meetings are going to be held via Zoom at a minimum. And then we're also wanting to do a training with the board either before or after the January 27th Board of Adjustment agenda. Again, that either be in person if we're in person or over Zoom if we're still having to meet over Zoom. So if you guys have any topics that you'd like to have discussed or if you'd like to have any more information on, just feel free to shoot me an email or reach out to me.
Okay. Yep. And Bert, for that training, and certainly depending on the topics, would you guess maybe hour, no more than 90 minutes?
Yeah, that sounds about right. It just depends if people have a lot of topics, and I could see it going longer than that. But the few things that staff definitely wants to cover, I think we could cover within an hour to hour and a half.
Great. Okay. All right. And if anybody's got a preference, you can email Bert. But like today, when that time comes, if we're still online, we would just stick around online, take a little break, but then just do our training online and go from there.
Yep.
Okay. All right. Is that it?
That's all I have.
Okay. Colleagues and city staff, thank you so much for all your professionalism, your caring, concern, and your good judgment. I wish you all well. This hearing is adjourned.
Thanks, everyone.
Bye, everybody.